Rise, please. Hearing. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Washington City for the Commonwealth. Join near. If your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. My name is Amy Blake. I am joined today by Justice Joseph Ditkoff to my right and Justice Andrew D'Angelo to my left. We are your panel for the 6 cases in this session this morning. A couple of rules, as most of you know, as you've been here before. Each side is permitted 15 minutes of argument. There is no rebuttal. I can assure you that we have read all of your papers, so you should get right to your argument. We did have a request to change the order this morning, and we don't want to upset the Superior Court judge. So with that, we're going to call John LEWIECKI, I'm sorry if I've mispronounced that, versus Pepper Grove LLC, docket number 23P1110. Counsel, good morning.
Good morning, Your Honors. May it please the Court, thank you for the accommodation. My name is Thomas Moriarty for Pepper Grove LLC. This case involves a disputed area of undeveloped land in Hingham, upon which there's a claim of adverse possession and prescriptive easement. Pepper Grove has 4 points on appeal. The post-trial motion to amend to pursue a claim of easement over the northern trail was erroneous. The acceptance into evidence of a new survey post-trial was error by the trial court. The easement claim over the northern trail was not tried either by express or implied consent. And finally, the trial court erred in granting the plaintiff adverse possession in areas shown on the plan that was filed with the second amended complaint post-trial. As an initial matter, Your Honors, the plaintiff's claim through trial were for adverse possession and prescription on a discrete area of property that it described as the disputed area, which was reflected in a plan. There was no claim for prescription or adverse possession during the period of trial outside the area that it identified as the disputed area. And that is the procedural and substantive reality that informs the dispute, at least as regards the prescriptive easement. The defendant was prejudiced, Your Honors, by the trial court's allowance of the post-trial motion to amend. The defendants accept that there are liberal pleading requirements with regard to Rule 15.
So if I could just ask you, what you do, I think, suggest that some things you were aware of in terms of a prescriptive easement claim.
Absolutely.
Can you be clear for a moment as to which things you say you knew were being tried and which were not?
Any claim with regard to the lawned area adjacent to the LEWIECKI's property that was
none
itself
of the trails
lawned.
or the trailheads?
Trails or trailheads that were within the disputed area, there was some testimony with regard to. No claims, I should say. No claims with regard to any of the extension of any trail beyond what was identified in the Hoyt plan as the disputed area, from the disputed area to Accord Pond. So none of those claims.
So what would the evidence have looked like, or how would your presentation have been different?
Oh, we would have been able to address, quite frankly, the uses outside the disputed area and the uses of the trailheads. So, in fact, the focus of the trial was on the claims that were within the disputed area. In fact, the testimony that was elicited from the plaintiff during the trial was that they were not asserting a claim outside the disputed area. So there was no need for defendant's counsel at the time, trial counsel, to address those issues whatsoever. Now, clearly, the dearth of evidence is reflected on the record in any event.
So Libby Emerson gets asked, you and your husband are not alleging this case that you adversely possessed any more than the 9,000 square feet shown in the Hoyt diagram, are you? Answer, we're alleging 9,000 square feet and the trails.
The trails, Your Honor, yes. And as they refer to the trails, it's all within the disputed area.
Well, but if it's 9,000 feet and the trails, how could it be just the 9,000 feet?
Because they define, well, no, because the trails are within the 9,000 feet. If you look at the
Yes, but
record,
the word "and" means in addition.
it's clearly a layperson uses the word "and," but if you look at the record, Your Honor, that we've highlighted, the only trails that are referenced are tied back to within the disputed area. In fact, the testimony that we cite from pages, it's on 127 of the record and 132 of the record, Appendix 3. Mr. LEWIECKI is asked during the trial, okay, and those trail systems, are they entirely on the disputed area? Not all the trails that exist are on the area that is being claimed. That's on page 127 of RA3. He was also questioned, and what trail are we on in the photograph shown? I believe that this also is the trail that's beyond the scope of what Hoyt drew. So this is beyond the land that you are claiming in the case? Yes, it is. So while there may have been an anomalous "and" in that earlier answer, there could not be more clarity with regard to Mr. LEWIECKI's response in that regard. He clearly states that there are trails outside the disputed area that we have no claim to in this case. So jumping forward, I suppose, to the question that immediately presents is whether this issue could have possibly been tried by express or implied consent. There's no suggestion in the record, and there's no argument made that it was by express consent, so the question then becomes, is it by implied? How could the defendants have understood that they were trying a case with regard to those trails outside the disputed area when the plaintiff himself disavows that he has that
What
claim?
about your post-trial brief? I mean, it was your predecessor who wrote it, but it starts by saying the area claim can be broken down to 3 conditions: a small strip lawn, forest, and 3 existing paths, and then discusses how the claim restricted easements must be denied because they failed to demonstrate by clear proof the use of a passage that was substantially confined to a regular or specific path. It seems like you specifically briefed the prescriptive easement over the trails.
Absolutely. Absolutely. But those are the trails within the disputed area, Your Honor. There is no argument. There's no defense being advanced that the Hoyt plan—
You think that how could it not be a regular or specific path within the disputed area? It's actually in the plan, exactly where the path is. Doesn't it have to be interpreted as beyond the drawn area?
So there are 2 things, Your Honor. If you look at the Hoyt plan in RA3, or RA1, I'm sorry, 139 in the record, there's a portion of a plan, of a path drawn. It terminates within the disputed area. It doesn't show where it goes from there. The defendants are not suggesting that the Hoyt plan doesn't show something, but there was no testimony from Hoyt that was introduced at trial. The only testimony that came from Hoyt was post-trial, but there's no dispute with regard to the existence of that portion of the paths within the disputed area. The omission, Your Honor, from the testimony—
If there's no dispute, then why would you write that they failed to demonstrate by clear proof the use of a passage that was substantially confined to a regular or specific path if there's no dispute about the path inside the disputed area?
So there's no dispute about the existence of an area inside the disputed area. So that path is shown. The deficiency, the defect with regard to the plaintiff's evidence was that they didn't introduce any affirmative evidence that they used the path regularly or that their use was exclusive of that trailhead area. So if I was going to try to break it down between what was in play at trial and what we say wasn't, there's no question that the lawn area was established. It's outside the wooded area. Then there are some paths that are shown on a plan, the Hoyt plan, no dispute about that. Those paths terminate within the disputed area. There's no dispute about that. So everything outside the disputed area was not in play. Then the question, Your Honor, was what evidence was introduced by the plaintiff that they actually used any of the trailheads that are shown on the plan, and what areas did they use on the ground that correspond to those existing trails. The trial court itself found that the plaintiff did not introduce sufficient evidence to demonstrate that their use of the southern and the middle paths was in a discrete area. So even looking at the plan, based on her view and the testimony that was entered, there was nothing that connected what Hoyt drew to their use. And if you look at the photographs, you'll see that there isn't really a defined area. So those photographs provide no supplement to the oral testimony that was offered at trial. The trial court's finding with regard to the southern and the middle trails was that it wasn't established for purposes of prescription. Then the court went on to say that they had adverse possession over those trails, despite the fact that there was insufficient evidence to satisfy the burden of prescription. Now, obviously, adverse possession requires one different element than prescription, and that's exclusivity. So it's the defendant's position that it was impossible, it had to be error for the trial court to conclude that the plaintiff didn't satisfy the lesser burden of adverse possession, but did satisfy the obligation with regard to adverse possession. So prescription is a lower burden, adverse possession is a higher burden. The court said they didn't meet the burden with regard to prescription. That's another reason why certain of the argument made by the plaintiff is indefensible in this circumstance. What the defendants rely on is a case that stands for the proposition, essentially what I just said, that you could almost think of a prescriptive easement claim as a lesser included of the adverse possession claim. And the case they rely on discusses that concept and says, well, a party can be on notice that a claim for prescription is being advanced with regard to a claim of use of an area because they're aware of everything, and if they don't prove the exclusivity, if they prove everything else, they get the prescription. But that case, and the principle that comes from that case, is that if there is a dispute with regard to the same area, the plaintiffs could establish prescription over that same area if they simply fail to demonstrate exclusivity.
Is that the unpublished case that you're referring to?
Your Honor, that is, give me one moment. That is Norton v. West.
Okay.
I don't have a cite for it. I know that the plaintiff cited it. The difference is that case does not stand for the proposition that if there is a dispute with regard to adverse possession over Area A, that the defendant is on notice that there is a prescriptive easement claim with regard to Area B. And that's what we have here. What we have in this instance is a claim that is contained within the disputed area as shown on the Hoyt plan that included an adverse possession claim. But there was no separate claim over the other areas with regard to prescription. So the plaintiff could not have been on notice and is not fairly said to be on notice because there was an adverse possession claim over a completely different area of land on the disputed parcel.
Can I ask you about a different claim that you raise?
Of course, Your Honor.
With respect to the submission of the plan, it seemed to me that understanding that you disagree with the judgment, that's why you're here today, for something to be recorded, it needs to be correct in terms of what the judge ordered. So if this is what the judge ordered, notwithstanding that you disagree with it and that's why you're here on appeal, what was the error in the other side presenting exactly what the judge was going to enter as a judgment, right? We want our land court records to be correct. So I'm having trouble with that claim.
So there's two components to that response, Your Honor. There was no error per se in Mr. Hoyt doing that which the court ordered, right? So the court said, provide this plan.
Right.
The problem with regard to the approach was that the plan that Mr. Hoyt was asked to prepare was not supported by any evidence in the record. So what happened was effectively—
Is that the 10 feet to the 4 feet?
So not only the 10 feet to the 4 feet, but we could use that as an example. So what Mr. Hoyt did really without direction was to prepare a plan that showed 10 feet. with no evidence in the record whatsoever that supported the 10 feet. But he did so. He presented it to the court. The court, sua sponte, determined no, that the 10 feet is too wide, set it at 4 feet. But there's no evidence in the record that supports the 4 feet either. So what happened was a plan was submitted post-trial. The defendants could not and did not take the position that what Hoyt did was inconsistent with what the order was. So we didn't come up with a conflicting plan because it was accurate. The difficulty from our perspective was, how do we challenge what Hoyt has done or what now the court has ordered Hoyt to do with a subsequent plan alone when we've had no opportunity to cross Hoyt with regard to what he did? Clearly, the 4 feet he did because the court said do that. The 10 feet was indefensible, but neither location was defensible because there was no evidence in the case that supported that location. So we don't challenge the fact that there was adverse possession with regard to the lawned area. We don't question whether or not there was a dispute in play inside the disputed area. But what the defendants maintain is that to connect the disputed area to a cord pond, that was not in play, and the adverse possession with regard to the trailheads is not defensible. Thank you, Your
Let me just
Honors.
make sure there's no other questions. I don't see any. We'll take the rest of the argument on your brief. Thank you.
Thank you, Your Honors.
Mr. Sullivan?
Good morning. My name is, may it please the Court, my name is Walter Sullivan, and I represent the appellants, John LEWIECKI and Libby Emerson, the owners of the property that abuts the premises at issue here. As the record reflects, my clients have owned that property since 1997. And as the trial court found, they have used the disputed area and the path since approximately 1998. In fact, the trial testimony was very clear and laborious that my client had done all kinds of work to the northerly trail starting in 1998, specifically.
So why not
Libby
add
Emerson.
a discrete, clear claim for prescriptive easement over the 3 trails and trailheads?
Well, I will point out to the court that the verified complaint properly was amended to make it more clear. However, in support of the motion to amend and why it should have been granted consistent with the rule of law of Castellucci is the fact that this was never a question. In fact, the original letter that was attached to the verified complaint to the appellant indicated that the LEWIECKIs were claiming the disputed area plus a series of 3 trails, 3 paths. That's part of the record, part of the verified complaint. Moreover, it was acknowledged by the trial counsel for the appellant in a motion for injunction that my clients had claimed 3 trails, and that's in the record appendix, volume 1, 123 through 125. Additionally, in his opposition to the motion to amend complaint originally filed when the Hoyt plan was first introduced, he acknowledged 3 paths, 3 trails. It was part of both pretrial conference memorandums by both submissions from both parties that all 3 trails were claimed. It came out in discovery. It came out in trial testimony. There's an affidavit from John LEWIECKI claiming all 3 trails as part of an opposition to a motion for injunctions, making him remove the chicken coop from the disputed area that's no longer in dispute. Further, there was a view by the land court judge, and all 3 trails were traversed, especially the northern trail to the pond, and there are photos in the record appendix with the parties walking, including trial counsel for the appellant. So clearly it was knowledgeable. As evidence that it was known at trial, aside from cross-examination of the plaintiffs by trial counsel, is the fact that trial counsel for the appellant sought to introduce into evidence a sign which indicated that access to the pond was prohibited. And the only way my clients could get to the pond was through the northerly trail. That was established at trial.
But did that sign come into evidence?
It did not come into evidence.
How do we consider it?
I believe that, I think it was testified to, but I don't want to say that, Judge, but I think it was part of the record. I'm almost positive. I can submit a supplemental brief on that part. In fact, there's a colloquy, excuse me, Judge, between trial counsel and Judge Roberts where he indicated about the northerly trail, you can't grant them access, it's against the law. And she pointed out to him correctly, I'm not reviewing their right to the pond, I'm only getting them to the shore. If they establish the northerly trail, that's all I can grant. And that was part of the record, the trial record, Judge, so I apologize that I'd forgotten that part. But that is in my brief, too. So using the case of law and the liberal standard for amending the complaint, clearly we meet the factors here. There was no surprise. It wasn't even brought up in his post-trial brief about the northerly trail that was explicitly testified to, photographs into evidence of the northerly trail. He was on the trail that we were walking down to the pond. And obviously the judge was part of that and considered that in her findings. And when she denied his motion belatedly, first when this was introduced at the motion to stay judgment, she indicated she had gone back over the record and that it was known and litigated before trial, during trial, and obviously it was part of the post-trial request for findings of fact that we submitted, and it was mentioned in his post-trial filing. So there clearly was no surprise, there was no dilatory tactics, no bad faith, and so the motion to amend the verified complaint was proper.
In the pretrial memo, it's, the defendant says the area in dispute consists of a small lawn, 3 paths, and dense woodland. Are those the 3 paths that counsel was discussing?
They are, and I would disagree with my brother when he was talking about what was claimed as part of adverse. I think what he's referring to is the trailheads, and there was extensive testimony how they cultivated those. It's also replete all over the record that what trial counsel for the appellant tried to establish was that the usage of the paths had not been consistent and they hadn't been located in a specific area. The judge flatly rejected that based on the documentary evidence, which included photographs, and her own view. It was obvious that the path was part of it, but she rejected our claims as to the southerly and middle path. She found that those were more woodlands and stuff. And there is a claim here that the wrong standard was used for woodlands. As the judge found, and we agreed, there was no award of woodlands. She specifically found this was improved, that our client had established that over 22 years they had used these open notoriously without permission and satisfied the standard for prescriptive easement. So again, we argued there was no...
Let me ask you this then. Is it your view that if you bring a claim for adverse possession over, I'm going to call it premises X, that the LLC is on notice from an adverse possession claim, that you are also arguing if we don't get adverse possession, we get prescriptive easement?
Well, I think that's what the Norton versus West case cites that my brother alluded to and which in our bill. I think that's the proposition it stands for. I don't agree that that's necessarily what we're talking about here. What we're talking about is that it had been established in pretrial pleadings, if not really distinct in the verified complaint, that we were alleging all 3 paths, not just the trail.
But it seemed that you were alleging you had actual adverse possession of the paths, and that you were excluding people, not just a prescriptive easement as you started the case. Is that right?
I agree with you, Judge, and that's an oversight on my part. You're absolutely right. We were alleging that we established adverse possession. In my opening statement, it says that, and it's also, I do want to point out that, again, trial counsel for the appellants acknowledged the pass in his opening statement at the trial. Or in the alternative, we are arguing prescriptive easement. And I think that Norton versus West stands for that proposition. But why we're citing it is we're saying that it was warranted under these circumstances where there was no surprise. It was acknowledged in multitude of pleadings and evidence at trial that it's clear that this was tried by consent. Certainly implicitly, it was acknowledged in opening statements. It was acknowledged in the questioning cross-examination, as Justice Ditkoff noted when he was cross-examining Elizabeth Emerson. He clearly knew, it was clearly with consent, and it was established well before trial. And so the motion to amend the complaint after trial was appropriate for 2 reasons, because there was no surprise and also because this was tried with consent. I'm not sure exactly if we're still talking about the amended survey plan, but we've noted in our brief that it was appropriate, and I would point out that in
But
Miller...
what is the record evidence to support either the 10-foot or the 4-foot path?
I'm sorry, could you...
What's the record evidence, whether it be the 10 feet that Hoyt included or the 4 feet that Judge Roberts ordered?
So, okay, so what I would say is the court instructed me to have the surveyor, Hoyt, go out there and do a survey. So he went out, did a survey, and he drew what he saw, okay? She rejected that because it was...
And that would have been 10 feet?
It was, I'm sorry, 10 feet. So she rejected that and said it wasn't that wide, you haven't done what I wanted. Moreover, she argued that the grant of adverse possession, which was approximately 9,000 square feet, she only gave 7,200. And she pointed out very early in the trial, I've never given a box of adverse possession. Nobody actually possesses a box. And so she kept talking about a U shape, and that needed to be corrected. So when my motion to accept the plan was denied, and she offered the plaintiffs the opportunity to have their own surveyor check those, they went back out, resurveyed, and submitted the plan, and she indicated that was consistent with what she had found. And we remedied...
Did she make a finding somewhere that it was 4 feet? Because I didn't see that.
Well,
Or are we implying it based on her view and then her subsequent orders to your clients to get a new survey?
I would say all of that plus the evidence at trial that was significant. There was testimony from 7 witnesses on behalf of the appellees who talked about the trails, the usage, using it for canoes, dirt biking, and all that sort of thing. There were photographs and evidence and the view. So I would say it was the compendium of all of those things that the trial court judge found, and why she ruled that it was only 4 feet wide, and why she also ruled that it wasn't 9,000 square feet of adverse possession, it was approximately 7,200, because she felt it hadn't been tended to, and it had resorted to woodland, and she gave no woodland. I would like to point out, with respect to the argument about the amended survey plan, Miller versus Abramson, a case cited by both of us, this court ruled that having an amended survey plan was the appropriate thing to do and not a clear error by a trial court judge. Obviously, for policy purposes, once this is resolved, for everybody to have clear title, there has to be a specific survey plan, not just a judgment without a plan. So I would argue that that's pretty clear. The adverse possession that the court awarded for the lawn and all the other area that they dispute in the trailheads, I would argue that an objective view of the evidence, the photographs, the testimony, clearly shows that the judge was within her discretion to make that finding. It was most certainly not clearly erroneous, especially since she was the one who did the site view and made her own determinations, and it was consistent with the evidence. So for all the foregoing reasons, the appellees respectfully request that this honorable court uphold the trial court's judgment for prescriptive easement and adverse possession and her denial of the Rule 59 motion. If there's any questions.
I don't see any additional questions. Counsel, the case is now under advisement. Thank you both. Excellent briefs and argument.
Thank you.
Hopefully we got you out in time, counsel.
Thank you, Your Honor. The frying pan into the fire.
Please give our regards to the judge.
I certainly will, Your Honor.
And the next case on our list is Pierre COLL versus Plimpton Conservation Commission, docket number 23P1182. Might as well stay in the land court arena. Good morning, counsel.
Good morning. If it pleases the court, I'm Nicholas Shapiro. I'm Phillips and Angley. I'm counsel for the plaintiff appellant, Pierre COLL. In this case, Mr. COLL owns the property at 47 Mayflower Road in Plympton, Massachusetts. Mr. COLL wishes to construct a modest 1,800 square foot home, single-family home, together with an associated garage, septic system, and private water well, all for his personal use. The property is 14.7 acres in size, when applicable zoning requires 120,000 square feet for a single-family home. The property is largely comprised of wetlands, but has 1.19 acres of otherwise developable uplands. The property is also already improved by a pre-existing access drive and wetlands crossing, but which has no stormwater management system to speak of today, and is presently comprised of hard-packed dirt, which is impervious. Local wetlands laws impose a 100-foot buffer to the wetlands, which under the Commission's regulations is divided into a 50-foot inner zone and a 50-foot outer zone. So the net result of this is that only about a quarter of an acre, around 10,000 square feet of the overall property, lies outside the technical territorial jurisdiction of the Commission. As a consequence, Mr. Cole filed a notice of intent in 2021 in order to build this home. Those proceedings extended for over a year, included 2 peer reviewers and 6 different design iterations as the project got more and more improved to remediate any kind of wetlands issues. During those proceedings, Mr. Cole actually petitioned the PLYMPTON Zoning Board of Appeals for a dimensional variance in order to site the home in the rear yard setback in order to push it even further away from the wetlands. Unfortunately, the board denied that relief.
So I think we have a sense of sort of the iterations of what happened.
Absolutely.
And you have limited time. I actually have 2 questions.
Sure.
The first, I hope, is easy, which is, you seem to disagree on what our standard of review is.
I don't believe so, Your Honor. I mean,
Say it's a de novo review.
De novo review because it's a 12C motion. So it's a de novo overall procedurally as a matter of the rules of civil procedure, but it's still a deferential standard review.
Okay.
There's no dispute. This is classic administrative law. It's arbitrary, capricious, lack of substantial evidence.
Just make sure I got it.
Yep.
De novo on the Superior Court, but deference to the Commission.
That is correct, Your Honor. Yep, absolutely.
So that was an easy one. Here's my second question.
Yes, absolutely, Your Honor.
With all the iterations, is there a place on this parcel where this structure could be located that would be in compliance?
No, Your Honor. And actually, that dovetails into one thing that I wanted to alert the panel's attention to, which is that obviously I reread all local law in preparation for today, and I wanted to alert the panel's attention to Section 290-6F of the local wetlands bylaw. That provision specifically empowered the Commission to grant waivers.
Give that to me again.
I'm sorry, it's 290-6F. So that provision of the bylaw, so this is a little bit complicated because there's both rules and regs promulgated pursuant to the delegation of authority in the bylaw, and those rules and regs allow for waivers from various performance standards, including the inner zone at issue here. The bylaw itself allows for an omnibus waiver that somehow has never been discussed heretofore, and I just want to draw the attention of the panel to it, because that provision allows the Commission, empowers the Commission to grant waivers from pretty much any requirement in the rules and regs upon a tripartite finding, some of which track the same waiver criteria in the rules, but there is a difference. So that the 3 criteria under the bylaw waiver provision that authorized the Commission here to grant waivers even from their waivers under the regs included, I can't comply, there are no alternatives, to Your Honor's point.
And that goes to the regulatory taking question that's not before us.
Yes, however, this is why I bring it up, is that criterion 2 is also like the rules and regs in that all efforts have been made to minimize impacts to the greatest extent feasible. However, and it does omit in that second criterion a showing of no significant adverse effects to the wetlands. So that omission seems telling. But then the third criterion is also different than the third criterion under the rules and regs, which allows for the grant of a waiver when there's overriding public interest. I think that's more or less the functional equivalent of the public benefit fight we'll probably have this morning, but also says or is necessary to avoid a regulatory taking. I think if you look at the board's decision, that provision in the bylaw, I don't think they were even thinking of it, I don't think they were aware of it, and the decision itself reads as, we would prefer a regulatory taking for the purposes of preserving wetlands because without a house, we believe somehow that would be better for the wetlands. Now,
And that was raised below?
below we've from the jump, we've said that this is like, by analogy, this is like Shirley Wayside, the SJC decision in the special permit context, where we have a mixture here of of arbitrary and capricious misapplication of local law, misinterpretation, reliance upon verboten grounds such as future illegal activity, misinterpretation of what public benefit is, but also a lack of substantial evidence for all of these things as well. And so this was just not on their radar at all. One of the reasons why it's not a matter that's been pressed is because, with all due respect to the Commission, even if the only criteria were the waiver criteria and the rules and regs, this was still an erroneous decision. If we go through the three actual specific grounds, now we rely on Fafford and Fieldstone for the arbitrary and capricious, legally untenable piece, and then this court's decision in Pollard for the substantial evidence issue, which is, if you have over a year with 2 peer reviewers, 6 design iterations, the final letter from ADL in March of 2022 said no comments were left unaddressed. Under those circumstances, it's not permissible legally to say, I'm still unpersuaded you haven't met your burden, but that's precisely what happened here. And if we drill down on, there's really 4 granular grounds for the denial here. One is clearing 13,000 square feet for the building envelope will dry out the wetlands. Now, even the motion judge agreed there was no substantial evidence for that in the record, but the basic undisputed facts of the project in this land belie the claim. So here, the inner zone was going to be inviolate. The inner zone was not being cleared at all for the purposes of the building envelope. So you're going to have a 50-foot fully wooded buffer zone between where the house is being built and the actual vegetated wetlands. Also, 13,000 square feet of clearing is only a quarter of the developable uplands. So the idea that this was going to be some massive clearing in the outer zone, I think, is unfair as well. But most importantly, it's in the record, it's in the submissions of Grady, my client's engineer of record, that this is a so-called palestrine forested system. This is not a marsh we're talking about here. This is actually a wet forest. So the wetland itself has a tree canopy. So the idea that somehow building a house in the outer zone when there's an intervening wooded buffer and then the wetlands themselves are wooded, the idea that the wetland would dry out is just, it's fantastical. The next ground that the commission gave was what we've already talked about prospective illegal conduct, was that we just don't believe that more trees won't get cleared. Under Fafford, under City of Boston v. Quincy Concom, under procedural due process, this is just not a basis for a quasi-judicial tribunal to deny relief. Just as we presume good faith and regular order on the part of governmental officials, we also presume that citizens are going to comply with the law. This is why we have a presumption of innocence in criminal cases. This is why bad acts evidence is not allowed in trial courts throughout the country. And so this was, when it talks about cumulative future effects, what the bylaw and the rules must be talking about is legal conduct, that we're allowing you to do something, and in doing that thing that we're allowing, there could be knock-on effects. So it was not really...
So the whole idea about buyer beware, right? What did your client know when he bought this piece of property?
Well, he knew that this was a 14.7 retreat lot, which under zoning was allowed to be developed, and it was a retreat lot with 1.19 acres of developable uplands. And he's seeking to build his own home there.
Do we know in the record how far or how close the nearest home is to this locus?
Not that far, Your Honor. This is a residential area.
On the map, it looks really far away.
Well, it is because this is a rural residential district. I mean, it's 120,000 square feet lot minimum for a lot of this size, right? So that's a hair under 3 acres. So it's already not a very densely developed residential area to begin with, but the closest things are all houses. And in fact, even on the Title V piece, my client cited his septic system so that it'd be at least 200 feet away from the closest private drinking well, which is 4 times what Title V requires.
Counsel, do you agree that the proposal permanently alters the BVW in the buffer zone?
So that's a great point, Your Honor. we are doing work in the inner zone, and that's actually, from my perspective as a dirt lawyer, the great offense here, because the only work that we're doing in sensitive areas is to improve wetlands ecology.
That's your position, but the ADL report says what you want to do with the driveway will make it worse.
With due respect, Your Honor, I really don't think that's true. There's no stormwater management system today.
The existing dirt pathway is improved with gravel, but no provision is made to infiltrate and treat stormwater. Gravel can easily become compacted and not allow rainwater to infiltrate into the ground. This can lead to direct discharge of driveway runoff, a potential source of pollution into the wetland at the crossing. That's the ADL report. I know your report says the opposite, but why can't the commission believe that?
I don't believe our report says the opposite. One thing that's confusing for the panel is that ADL gave the same letter iteratively and made edits to the letter.
Right, so in February, they say, a waiver is still required for the wetland crossing, no public interest is proposed, and the March report has the same conclusion.
So it doesn't have the same conclusion, Your Honor. At present, it's hard-packed dirt, which there's evidence in the record, in the administrative record, that that's impervious and it's already having indentations that have standing water today. And so part of this project is to strip the existing access drive and replace it with gravel so that the road itself would be pervious, not impervious. Then ADL also recommended a 5-foot separation between the adjoining wetlands.
I'm looking at the May report. At the end, it says in bold, a waiver is still required for the wetland crossing and associated driveway. No public interest is proposed.
Okay, so two things about, that's the same language that appears in the first letter, because a waiver is required. There's no dispute here, Your Honor, that a waiver is required. If you're, under local law, if you're doing work in the inner zone, and, the culvert, installing a culvert, right now there's no hydrologic connection between the two adjoining wetlands. They're completely isolated, and one of them is a finger that is quite small. And so it's actually in threat of ceasing to exist, in part if it's not connected. So all of the work installing a culvert allows a hydrologic connection between the two, and that itself is a wetlands benefit because they're isolated by the existing drive right now. And so the post-build conditions are going to be better for wetlands ecology for a number of reasons. The culvert creates a connection.
I understand your argument, but I don't understand why the commission can't believe the ADL report, which its final conclusion is you don't have any public benefit.
I would ask Your Honor to go back and look. That language has been identically carried forward in every single letter, even though every single recommendation that she made was honored by the time of the 6th project iteration.
Counsel, whether it's better or not, I'm asking, is it altering the BVW in the buffer zone?
You have to in order to install the culvert,
Okay,
right? So
the
that has a
answer is
2-to-1, but Your Honor, that required a 2-to-1 replication area, both under state and local law. And under state law, the commission specifically held that replication area would function as well as the existing wetlands. So net, there will be more wetlands post-build than there are today.
Counsel, it alters it. And once it alters it, this goes back to Justice Blake's question, it requires a waiver. Whether it alters it...
And there's no dispute.
Okay.
Right,
so
but
if it requires a waiver, as the buyer, you know, this is in the zone. If I change it / alter it, I require a waiver. So the buyer was aware that they required a waiver, and a waiver is discretionary.
Right, but discretion in any court before any quasi-judicial tribunal is not boundless. That's why abuse of discretion is part of the arbitrary and capricious.
I'd like you to explain.
Right. So it's an abuse of discretion because there's evidence that the access drive is being used today. There's no limitation on the right to use it today. And in fact, today it doesn't have a stormwater management system. So during storms, sediment is flowing in there. As it stands today, both wetlands are not actually connected hydrologically. That's another benefit. As it stands, post-build, there will be more wetlands post-build than there are today.
So where's the clear and convincing evidence that your driveway is better?
I'm just going through it, Your Honor.
It's just the Grady report, right?
It's not just the grade.
But what else?
Again, with due respect, Your Honor,
what else is in this record besides the Grady report that establishes that the driveway is better?
The fact that every single mitigation, again, Your Honor, the only work we're doing within the sensitive areas
Right, now
Because this is a
I understand the facts in the Grady report, but is there anything besides the Grady report that has these facts in it?
It is the final letter of the peer reviewer that all specific comments about things that could be done in order to benefit wetlands, they were all done by my client over a year of iterative
All right,
design
so
changes.
It's the
And so
reports. It's the reports, right? I mean, I'm not missing anything.
Right, it's also, you're absolutely correct, Your Honor, but I would really urge Your Honor to look at ADL's letters. They're literally, it's the same letter, but she makes edits to it iteratively, so it's
I get that. I have gone through each report and how they're different, but if I got all the reports and I really understand the reports, I've got the evidence, right?
So I'll just summarize it again, Your Honor. ADL said you should have 5 foot of physical separation between the surfaced road and the wetlands. We're doing that. Gravel, we're stripping it down and we're putting gravel so that what is impervious today will be pervious tomorrow. And we're installing a drainage ditch along the whole length of the access drive as it extends through the wetlands and in the inner zone in order to treat and infiltrate stormwater so sediment doesn't flow into the wetlands post-build. And there's going to be a culvert added to that will allow a hydrologic connection between the two wetlands. All of these things are benefits to wetlands ecology, and we're only doing that work on the, and this is typical for wetlands permitting, is that I know if I'm going to build a house, even though that may be 10 vehicle trips a day, I still need to do things to ensure that that access drive, because it's going to be used marginally more, is making sure that there's going to be no injuries to the wetlands. And so even though I think net, once you look at 296F, you don't need to prove no injury at all. I think that
I'm pretty deep in these reports, and I'll get deeper before we decide this.
Very good. Thank you, Your
I
Honor.
think we will have to leave it there. And
Thanks so
Counsel, if
much.
you need the additional 2 minutes and 17 seconds, you will have it that we went over. So Attorney Mullen, when you're ready.
Just one moment, Your Honors. Good morning, Your Honors. May it please the Court. My name is Connor Mullen with KP Law, and we represent the appellee, the Town of PLYMPTON Conservation Commission. So I won't belittle the, unless Your Honors have questions, the applicable standard of review, as my brother went through it in the beginning of his argument. But what I want to emphasize for Your Honors' consideration in this matter is that in reviewing the different grounds that the Commission sets forth, under the applicable standard that the Superior Court correctly applied, so long as there's one reasonable ground for the Commission's denial decision, and as long as that ground is supported by substantial evidence within the record, that's the only thing that's required for the decision to be upheld. In my
So the wetlands bylaw can trump the WPA?
Your Honor, so with respect to the relationship between the Wetlands Protection Act and the bylaw, where a provision of a local wetlands protection bylaw or regulations is more stringent than the comparable provisions under the Wetlands Protection Act, then in that particular circumstance, if a decision is issued under one of those more stringent provisions, then that would be grounds for the decision to be upheld.
And
Again,
what case says that?
bear with me, I apologize, Your Honor. Well, Oyster Creek is one that could be cited too. I'm not sure if that's the one I specifically referenced in my brief, but
Okay, you can move on. We'll figure that out.
sure, of course. And it is in my briefs, Your Honor. I apologize. So to quickly iterate what makes the provisions that the Commission denied the order of conditions under more stringent, to quickly, list those, the Commission denied the project because it could not comply with the performance standards for, as my brother discussed briefly, the inner 50-foot portion of the buffer zone to bordering vegetated wetlands. That would be under Section 19C1 of the regulations. That performance standard is more stringent than the Wetlands Protection Act because it imposes as a default, a no disturb zone performance standard for that inner 50-foot buffer zone. That performance standard applies irrespective of whether that work in that buffer zone might alter the adjacent resource area, in this case, the bordering vegetated wetland. And that is the distinction between where the Wetlands Protection Act buffer zone is subject to regulation under the Wetlands Protection Act only if work in that buffer zone adversely impacts the adjacent resource area, whereas under the more stringent local provision of Plympton's Wetlands Protection Bylaw and regulations, there's any work within that buffer zone, regardless of its impacts to the adjacent resource area, is subject to regulation. I apologize, Your Honors, I thought there's a question. So the inner 50-foot buffer zone has a no disturb performance standard. The Commission declined to grant a waiver after finding that the project could not be, did not have sufficient public benefit or was not in the public interest.
What do you say to your brother's argument that the issue of the regulatory taking should be considered in connection with the denial of the waiver?
So that is it's an issue in this case. And under, I won't quote it in full, but my brother's referring to Section 290F of the bylaw. So given the procedural history of this case, so there is a regulatory taking claim that's been asserted, but that is not, the particular regulatory taking claim is outside the scope of at least what's on appeal here. Those claims were bifurcated.
So we can't consider it in connection with the three-part test for waiver?
I think that in terms of looking at that section of the bylaw, because again, there are waiver provisions which I've discussed in my brief at length under the regulations as well. I think that it would be appropriate to consider them, but the arguments, before, the lower court in the decision that affirmed the Commission's denial, which led us to this point here, those arguments weren't before the Superior Court either, just because the parties had stayed the regulatory taking component. So I'm not sure the extent to which
Have you done analysis of the regulatory taking claim? It's going to be pretty annoying if we affirm and then you lose the regulatory taking claim and then give them the permit rather than pay them.
So I apologize. Could you repeat the first part of your question? Have
you done analysis of the regulatory taking? I don't want you to discuss it, but are you feeling you got a good shot of winning on that?
Our position is yes, that we believe we will prevail when we get to that point if it becomes necessary. But we haven't extensively looked at it yet, just given the procedural history of this case. So just to go back to the distinctions between the Wetlands Protection Act and the more stringent provisions under the local bylaw and regulations, under Section 19C3 of the regulations, that also imposes a performance standard for the outer 50-foot buffer zone. That standard being that, while there's no, it's not the same no disturb component, but the regulations provide that any work within that outer 50 feet must not adversely impact either the inner 50 feet of the buffer zone or the adjacently located wetlands resource area.
Counsel, can the Commission use a potential future harm as a basis for denial? Because that was one of the bases they did in this case, and I'm struggling with what is the authority that they can do that?
One moment, Your Honor.
I think it was the future harm of they suggested that there would be cutting of trees.
So the short answer, Your Honor, is yes. The Commission is entitled to, in considering the impacts of a project, the bylaw and regulations allow for the Commission's consideration of both the present effects of the project and the impacts upon the wetlands resource areas subject to the Commission's jurisdiction, but also the, in addition to the immediate impacts, the implications. This is under Section 296D of the bylaw. The adverse impacts over time as a consequence of daily operation or existence of the activities.
Well, but that seems to me to mean that if you build something, you can look at that there will be a future harm based on what you've built. In this case, the Commission is suggesting that in the future, they will cut down trees in order to make the property better, and therefore we should consider that. There was no proposal that they were going to cut trees. In fact, there was a proposal that they weren't going to cut any additional trees. So how can the Commission sort of do that? Guess what the owner's going to do later on?
That comes back to, it's part of the Commission's consideration of the natural and consequential cumulative impacts of the project. So that's, the Wetlands Protection Act does not, under the state, does not contain provisions that say, that, a commission may consider what are the, future implications that may result from the project being presently proposed. But if you look at the burden of proof for the waiver provisions under Section 21D2 of the regulations, it's a burden of proof to show that the proposed work, including its necessary and required mitigation measures, and this is the key language, its natural and consequential cumulative effects will have no significant adverse effects upon the wetlands protection values. So the way that, the Commission, and I read that provision, is it allows the Commission to consider where its certain activity is reasonably foreseeable, future adverse effects resulting from a proposed project. One point I want to clarify to that end is there's a distinction between the natural and consequential cumulative effects and future potential unlawful activity, because that's something that my brother focused on in his brief and in his arguments. But in terms of future tree cutting, I want to emphasize what the Superior Court decision recognized, which is future unlawful activity. That's something that's not, permissible to consider, but a concern of potential future tree cutting, what the Superior Court found is that it's foreseeable that, given the proximity of the property to nearby trees, it at least was reasonably foreseeable that future owners might, in order to avoid risks of trees falling on the home, take the steps necessary to remove the trees lawfully. So with proper permitting, our whole argument about considering those future effects, this is even if the future tree cutting is pursued, pursuant to all necessary and required permits. It is still part of the natural and consequential cumulative effects of the project. And so the Commission, to that extent,
So I don't understand how there could be future tree cutting that could get a wetlands permit that would harm the wetlands. I mean, if it would harm the wetlands, wouldn't you not get a permit for the future cutting?
Well, so if you go back to the default for the inner 50-foot buffer zone is a no impact or no disturb performance standard. There is, the waiver provision. So if a future owner were to go apply for that tree cutting, say, to avoid damage to their home, the Commission may or may not, grant that, but they have the discretion to. Here, the same waiver provision was considered by the Commission, and the Commission found that the threshold criteria was not met for the work within the inner 50-foot buffer zone.
Is the Commission's concern that a future Commission will be reckless as to the wetlands?
I don't think that's a fair statement, or I don't think that would encapsulate what the Commission's.
I don't get why, if this Commission doesn't think that cutting is acceptable, that they think a future Commission will give a permit to cut. I don't understand that.
Well, I don't think that the Commission necessarily considered, it's even assuming that if a permit, would be granted, so that any tree cutting within that, along the border within the inner 50-foot buffer zone, would be lawful. I guess what I was trying to emphasize is if it is happening, that's a part of the kind of future considerations that the commission is looking at. I guess I'm not afraid that doesn't totally answer your question, but the commission's not concerned with how a future commission might determine or might act differently. It's as simple as the commission is considering the natural and potentially reasonably foreseeable consequences of a project. Again, someone could apply for a permit for that tree cutting. They could, maybe it would be, waiver would not be granted, maybe it would. But I mean, I think it's reasonably foreseeable that a different commission might, or that same commission in the future, could grant, a waiver for that tree cutting given the risk to a house. I mean, that just ties to, it's a extension of the cumulative impacts as a project as a whole, and that's why the commission considers it. So moving on from that point, unless your honors have questions on that component, I don't want to jump ahead too fast. But in the
Jump away.
Okay. I will stand still, but jump with my point, at least. So with the last 90 seconds I have, I want to emphasize again, the entire standard that the Superior Court applied is that, as long as the commission denies it on a reasonable basis that's under the more stringent provisions of the local bylaw, as long as that's reasonable, meaning a commission could find similarly. My brothers in the briefs have identified a lot of reasons why maybe a different commission might have granted the waivers instead. That's all fine because the standard is not, if a commission or if a court sitting in the shoes of the commission could allow the project, then this commission's denial decision must be, overturned. The standard is if this commission based it on a reasonable determination under the local and more stringent local bylaw, then the decision should be, affirmed. And in my briefs, and as the Superior Court found below, both the provisions for the inner 50-foot buffer zone, which is a more stringent provision under the local bylaw and regulations, and the performance standards for the outer 50 feet, Mr. Cole's inability to condition the project to satisfy those performance standards or to qualify for a waiver in the Commission's discretion led to the Commission reasonably denying the project for failure to comply with those performance standards. And for that reason, Your Honors, we respectfully request that the Superior Court's decision be affirmed.
Thank you very much. Thank you, counsel. The case is under advisement.
Thank you very much, Your Honors. Have a nice morning.
Our next case is the Department of Children and Families versus Mother, docket number 23P1336. I know counsel knows this, but as you approach, just a reminder that this case is impounded, so please do not use any names. And I understand Attorney Openshaw and Attorney Krasner, you're going to split your time evenly?
That's correct.
And the department is going to have 10 minutes and Mr. DeJoy 5 minutes, is that right? Okay, and who's Attorney Openshaw is going to go first?
Yes, Your Honor.
Okay, that answers all my questions. When you're ready.
Good morning, members of the panel, and may it please the court. My name is Laura Openshaw, and I represent the appellant father. The father is challenging the finding of unfitness, the termination of his parental rights to his 2 children, and the denial of a visitation order. Today, I would like to focus on 2 things. One is the limited evidence of parental unfitness that existed at the time of trial after he had spent a significant amount of work in therapy, and the role that the family's Puerto Rican heritage should have played in the judge's determination of whether there should be post-termination or post-adoption visits. Starting with the first, the father's therapy records demonstrated that he completed 19 therapy sessions over about 8 months. He started with one therapist, was transferred to another after that one left the practice, and both of them found that he had made some progress towards his therapeutic goals relating to anxiety. But the judge's findings didn't reflect any of that. There's nothing about his goals or his progress, and the findings actually don't reference his therapy records at all. The judge instead made 3 classes of findings that we submit are clearly erroneous, including some related to his participation in therapy, and what's left doesn't constitute clear and convincing evidence of unfitness. First, he addressed his struggles with anxiety through therapy, and there was no evidence of any other mental health.
I've got that the therapy all happened in 2021. Am I wrong about that?
That's correct. Yes, that's correct. So over 8 months in 2021. And there was no evidence of any other mental health struggles other than those relating to anxiety, which were addressed in therapy. The only substance use alleged by him was cannabis, for which he had a card. And there was no indication that his marijuana use ever stood to interfere with his parenting. As to his criminal record, he had just the 2 60-day detentions and the conduct that was alleged from January 2022. At the time of trial, there had not yet been a criminal trial, and so there was not yet a conviction on those facts. He had ended his relationship with the mother well before trial, and the judge soundly rejected the allegations that there had been domestic violence in that relationship. It's true that he didn't do every recommended service. He did do several, of course, therapy being the principal one, behavioral health evaluation. There was evidence that he showed the court investigator a certificate from a parenting class. And by the time that his engagement in services had become less consistent, it was not at all clear that there was a continued need for services, again, given that there was no evidence of substance use that stood to interfere with his parenting and no issues with mental health other than anxiety. It's true also that he had some difficulties in remaining consistent with his visits in the second half of the case. But it's important.
You only have 3 visits, one of which was in person, is that right?
So the evidence was that his last he had, kind of looking back from the beginning of the trial began in March 2023, that his last visit, most recent visit before trial was in January of 2023, and that in the second half of 2022, he'd had an in-person visit and he'd had a couple of virtual visits during that time. In the first year, he was much more consistent. And what's important to consider when looking at, in particular, the fact that there weren't a lot of recent in-person visits were the older child's medical issues, which made the logistics for in-person visits very complicated since the older child needed to have the foster parent available in case there was a neurological incident.
On that question, this was the child with the seizure disorder?
Yes.
What did Dad do to be in touch with the doctors to learn about this, to figure out how to prepare himself to deal with a child with a seizure disorder?
So there was testimony that the social worker was not aware of what the father had done. Of course, he wasn't present for trial. That was an issue, and so when we don't know the full extent of what he did. But even if we consider the children's special needs and the fact that he had been able to benefit, to engage consistently and benefit from the services he had engaged with, in particular that he'd had that period of regular engagement in his own therapy, and even looking back to the period of time when the younger child was in the care of the parents, where there were in-home services that were being provided, mandated reporters who were in and out of the home, who had very positive things to say about the father.
Well, I appreciate that you're sort of taking a left turn from my question, so I'm going to bring you back to my question. My understanding is the record shows that he had no contact with the medical providers at record 1, page 372. Are you contesting that?
No.
Okay, I appreciate that.
No. I just wanted briefly to address the fact that of his absence at trial. The judge was allowed to consider that he wasn't present, was allowed to draw an adverse inference from that, and the judge did that. But this was not a case where the father had abandoned the case or the children. This was a case where the father was in touch with his attorney, was giving the attorney information about that the attorney provided to the judge about his availability and his custody status. And I think most importantly, the father was in touch with the DCF social worker shortly before the trial concluded. It appears that the judge might not have noticed that bit of testimony when he made the finding about the father's being in touch with the DCF social worker, but it's significant because it showed that as soon as the father was out of custody, as soon as he was in a position to have visits with some normalcy, that he had his sons in mind and he was interested and cared about them and wanted to reconnect with them and with the department.
Couldn't the judge make the opposite finding where on February of 2023, 1 month before the trial, he didn't show up for a visit, didn't call the social worker, and hadn't been in contact with the worker since?
So it's true that my recollection of the record is that there were some visits that were scheduled and for which he did not appear and did not explain why he did not appear.
Well, this is after you just made the, I won't say leap, but that he cared after he was released about his children.
Yes.
I think the adverse inference could be once he was out, 1 month before trial, there was no shows, no contact, that was it. So why can't a judge make the opposite finding? He's now out of custody, and he's not showing up, and there's no contact.
I think that the question is, that's an inference a judge is permitted to draw. But I think that in view of the fact of when you take away the findings that we argue are clearly erroneous, it's a slender reed to build this finding of parental unfitness that requires clear and convincing evidence. And I think that the judge, didn't find abandonment and couldn't have on these facts, and that the fact that close to the end of the trial, the father was in touch with the social worker, I think shows that you can infer something. You can consider the inconsistency in visitation and the fact that he didn't appear for trial, but that's not unfitness. And that's not unfitness on its own or together with the residual issues regarding his parenting capacity. I just briefly wanted to touch on the issue with the visitation, that the judge's finding that there was no evidence that post-judgment visits would be in the best interest of the children is belied both by the evidence of positive visits and the fact that the father may well have been the children's only connection to their Puerto Rican heritage. I rest for...
I think we'll have to leave it there,
Yes.
counsel. Thank you.
Thank you.
Attorney Krasner.
Good morning, and may it please the court. I'm Sherry Krasner here on behalf of the appellant mother. Mother understands that an appeal is not a second bite at the apple. She also understands that this court affords great deference to decisions made by trial judges. But the underpinning of giving that deference to the trial judge must rest on the trial judge not making a clear error of judgment. And that means that the trial judge must weigh all the factors relevant to the decision-making process. And because that is precisely what happened here, the judge did not take into account all the facts and didn't weigh the record in its entirety in a reasonable way. This court must vacate and remand. And here I'm speaking specifically of how the judge viewed the history of domestic violence and mother's decision not to leave Florida. With respect to the domestic violence, it is true that the judge made a finding that mother was not a credible witness. He's free to make that finding. However, there was ample other record evidence that mother was a victim of father's coercive control and that he had a hold over her that undercut her ability to be a fit parent. First of all, this was a mother, we know from the record, who had been a victim of sexual abuse in her own family of origin. We also know from documentary evidence that she had been a victim of domestic violence by the father of her oldest child, not the subject children here. And we know that father seems to have had some sort of coercive control over her. This was a mother who had not really any criminal history before this case, but yet somehow she became the lookout for father for a series of car break-ins. And there's also the incident having to do with the dog, the pit bulls. And we know from the record that mother was making a serious effort to get rid of these dogs, that she had contacted the MSPCA. We know, too, that the judge's finding in this case is that father sicked the dog on the roommate while the roommate was holding one of the baby, the youngest child. But nowhere in that finding do we know anything about where mother was. And yet somehow she's gotten caught up in this, and she becomes the perpetrator in the eyes of the judge. And then let's remember back to what happened with the youngest child, that there was a report that came in that mother may be the victim of father's domestic violence. And the social workers, they screen in the report, and they say right in the report, we will make an unannounced visit to mother's home, because that is consistent with department procedures and protocols, that is what you do when there may be domestic violence. And yet they say that right in the record, it's consistent with what they're supposed to do, and yet they don't make an unannounced visit. Instead, they come to the home and have a group chat with the father present, and mother in that setting says, no, you know, I'm not a victim, and this is all a hoax. So for the judge to be so dismissive of the fact that mother likely was a victim of domestic violence and that didn't factor at all into his findings was an abuse of discretion, and this court could...
Can you speak to mother's mental health issues and the record evidence about whether or not she treated, took her medication, was compliant, denied having mental health issues, that whole piece of the case? Mother had been prescribed Seroquel after the birth of her first child, and there were concerns at the time, the first child of this proceeding. In this case.
And indications that she was compliant with it, although there also, she didn't meet the level to be committed at that time. It was just, so she started taking medication. There's nothing, the record to suggest that she didn't continue, at least for some period of time, to comply with her medication. When she got to Florida, she indicated that she had gotten on health insurance, but she had not yet found a psychiatrist. So there was some recognition on her part that this was something that she needed to address. It's also, the judge makes a finding, and I have the specific finding cited in my brief. I'm sorry I don't have it right at hand, but he makes a finding that she suffered from bipolar disorder and other conditions, yet the record evidence is that her treater at the time of the removal of the second child said that she did not believe that the bipolar diagnosis was correct, and that mother's primary diagnosis was PTSD, which in a way circles back to some of the issues of being
She moved to Florida in May of 2020, right?
April or May of 2022.
And then the trial was March of 2023, so
Correct.
almost a year. And then we had the transcript is reflective of some of her inability to control herself during the trial. That seemed to be consistent with at least untreated mental health issues. So wasn't that fair game for the judge?
The judge, under Yvonne, we know that the judge can consider mother's behavior during trial. It was difficult. Let's remember, everyone else was in person. Mother was participating on Zoom. She may not have always realized that this was a courtroom proceeding, and she was very emotional, but I'm not sure to make the leap that meant that she was in fact suffering from an untreated mental illness is completely reasonable on all of the circumstances. But there was evidence that she had obtained health insurance, and she was on a wait list to see a psychiatrist.
And it was her position at trial that she was fit and the children should be reunited with her in Florida.
Ultimately, she knew that she was not in a position yet to do so, and that's, see, I have very little time left, but just to say briefly that the judge's decision that for her not to come to Massachusetts when there were those open warrants that she believed were related to a crime that she alleged she did not commit, the judge said, well, this means she must not care about her children. And I think to make that leap and not to consider, she knew her children were safe, she knew her children were taken care of, and coming to Massachusetts to risk being incarcerated, in her mind was a reasonable decision, and to say that meant she didn't prioritize her children was not.
And how is a judge supposed to consider that? Is she ever going to come to Massachusetts to get her kids? Because the warrants aren't going to go away.
She explained that what she was doing is she was trying to earn money to retain private counsel to fight the charges. She also believed that she could provide a better life for her children in Florida, and that was something she had, way back at the outset of this case, she had talked about ultimately moving to Florida at some point, thought she could provide a better way of life for her children. So she thought she had a long-term project that would ultimately inure to the benefit of her children, and that not coming to Massachusetts on a regular basis didn't mean that she didn't care for them. I see them.
See if there are any other questions of the panel.
I'll rest.
I don't see any. We'll take the rest on your
I
brief.
rest on my brief. Thank
Attorney
you.
Krasner. Attorney Salcido? For those of you in the courtroom, we're going to take a brief morning recess after this case. Attorney Salcido?
May it please the Court, Richard Salcedo for the appellee, Department of Children and Families. The Department is asking this Court to affirm the trial court's decision of finding mother and father unfit and terminating their parental rights. The Court's 130 specific and detailed findings of fact demonstrate that close attention was paid to the evidence, and those findings taken together support the Court's conclusions. The children currently are in stable placements with long-term parents who were was found were meeting their needs and have spent virtually, well, the older child has spent his entire life in care, substitute care. The younger child, with the exception of about 9 weeks, has also been in care since.
What do you say to father's argument about post-adoption, post-termination visitation, particularly as it relates to the ethnicity issue?
I don't believe that has been, don't see anywhere in the record where that was raised as an issue that should be weighed in terms of, you know, the Court's decision regarding any contact with father, and has been pointed out, father failed to avail himself of opportunities to visit with the children when he had the opportunity to do so, including, as was pointed out just before trial in February of 2022, father chose not to attend a visit with the child. Not sure if that answers your question, Your Honor, but
So you think the issue is waived as, not as to the visitation, but as to the specific topic of the Puerto Rican heritage?
I would say so, Your Honor, yes. With regard to father, I just wanted to highlight a couple of things. With regard to his parental unfitness, he had what the record indicates is an extensive criminal record, which includes a number of different charges, including 24 vehicle property offenses, breaking and enterings, and other charges, which led to incarceration and his accompanying unavailability to his children. And at the time of trial, there was still an active criminal warrant. With regard to his engagement in his services, as my sister pointed out, he was engaged at one point in a number of services. The Court specifically talks about that engagement at the conclusory finding at number 15, and the Court acknowledges that father was engaged in therapy, that he had signed releases, and that he had participated or attended a number of visits with his children. But father failed to engage in any services that the Court found after February of 2022, which is basically a year or more prior to the beginning of trial. His visitation was also very limited. He only had 3 virtual visits and 1 in-person visit in that time. And as Your Honors also pointed out, he failed to contact or communicate at all with the doctor for the children, and it's particularly important with regard to the older child who had the seizure disorder, and there's no
evidence that he contacted the doctor to inform himself about that condition as was required by his action plan. And has already been indicated, father failed to attend the 5 days of trial for which the court found or made an adverse inference regarding father. With regard to mother, I just wanted to emphasize also a few things. That prior to the two subject children, the two boys involved in this case, mother had prior history with an older child who has since been adopted. And in that case, some very similar concerns were raised about mother's untreated mental health issues and other issues as well, including her penchant for engaging in belligerent behavior. There was, in that case, there was a documented history of domestic violence with the father of that child, who was not the father involved in this particular case. The two subject children were removed due to mother's continued abuse of substances during her pregnancies with both children. With the first child, the oldest, mother tested positive for THC and fentanyl at the time of the child's birth. And with regard to mother's move to Florida, that move came after a period of incarceration. Mother was supposed to spend time as a condition of her release in a program, but instead left earlier. She claimed that she was discharged, but court did not find that claim to be credible. She gave no notice to the department, relocated to Florida, and after her relocation there, 8 months later, or during an 8-month period, she failed to contact or communicate with the department and refused to provide her address or contact information there. The court specifically found that she has failed to engage in any services since she moved to Florida, and that's at finding 57. With regard to domestic violence, I wanted to direct the panel to the Record Appendix 2 at page 64, and that is a 51B investigation report where my mother is specifically asked about any issues with domestic violence with father, and she clearly indicates, she says, quote, actually, according to the record, that father is her main support, and she denied being controlled physically, emotionally, sexually, or financially by him. I would also point out, in terms of any of future or potential.
That report reads like the parents were together at first, but then they separated them for the discussion. Am I reading that right?
I don't recall that, Your Honor. It's possible that it is possible.
Well, that seems particularly important, right? Because if Dad was in the room with her, she's not going to say, he's beating me.
Right. There's no other evidence in the record, however, of any incident of domestic violence between mother and this particular father. There's no charge of domestic violence by father of mother, and no other, like I said, no other incident during their relationship, which lasted approximately 4 years, that there had been any mention of domestic violence. The first time mother mentions it, in fact, which is indicated or noted at finding 33, was during her trial testimony. Prior to that, she had not mentioned it before. And she mentioned it in the context of why she left or moved to Florida, and the court did not find her credible because she had given a number of different reasons why she left the state to go to Florida. Mainly, she claimed that it was to take care of a sick uncle. That claim, the domestic violence claim, is not really supported by the record or the court's findings. Unless the panel has any other questions or requests.
I don't see any additional questions, so we can take the rest of the argument on your brief. Thank you.
Thank you, Your Honor.
Attorney DeJoy?
If it please the court, my name is Mark DeJoy. I represent the two children, a 4-year-old and a 3-year-old. The 4-year-old's been with his adoptive parents his entire life. The 3-year-old has been the adoptive parents for almost the same time, save his entire life, save for the 9 weeks, which ended with a dog incident at some point where he was, I think, then pulled
And
from.
the boys are seeing each other?
On 118, Judge, they are seeing each other quite often. The judge's finding on 118 says that they see them quite often. And as you know, the third child is a brother too, and living in the child one's home, was taken before. Your Honor, the untreated mental health was a big issue regarding mother. She denied at trial that she didn't have any need for mental health treatment. In fact, at trial she also said that when she went to Florida, she got on the list for psychiatrists on the waiting list, but she only did that because she thought DCF would want that, Your Honor. Your Honors, mother's behavior, Your Honor, is clearly within the judge's purview to make the findings of what the judge witnessed at that time, the disrespect that was happening, and she only showed for the 3 days out of the 5 days. She was absent the 4th and the 5th day. The father didn't appear at all, and I do agree, Your Honor, the first year the father had great visits, well, I'll say good visits with the kids, was going to a parenting class, went to a parenting class. There was no evidence at trial how he learned from that parenting class, where the judge was unable to use that information because father wasn't there. The trial, the judge on the 5th day allowed the trial to continue again so father could make his way back from Salem. It looks from the record that the father was released, but didn't appear. So I think it's the judge taking negative inference that father was not available for the trial was proper.
Do you know if the probate court has the ability to bring a prisoner in?
I believe they do, Your Honor. I don't know. I believe they do.
This was juvenile.
Oh, sorry, I meant juvenile, yes.
Right, so.
Of course, and they do, obviously. That was a stupid question, never mind.
At least I didn't ask it, Judge. If I just could look at my notes one more time. One of the things the father didn't do, when speaking to the court investigator, he was not sure why the kids were in care. And the record is clear the kids had behavioral issues from the beginning. They've improved up until the time of trial. They continued up until the day of trial. The one issue that I think, the biggest issue I have is with what the parents' failures was, they never called the pediatrician, as Justice Blake brings up. DCF did a lot of work to try to navigate visits for the father because they needed to have somebody who was trained in the onset of seizures. DCF, when foster mother couldn't do it, it's my understanding that DCF provided that care, provided that person so it could happen. If you don't have any other questions, I'll be happy to rest of my brief.
I don't see any.
Thank you.
Thank you very much. Counsel, it's a difficult case, very well argued and briefed. It's now under advisement. We are going to take about a 10-minute morning recess.
I'm only going to be lying.
close the session. Please be seated.
Okay. Just going to briefly go over the rules again because I don't know that all of you were here this morning. So each side is permitted 15 minutes of argument. You will argue from the podium. There is no rebuttal. We have read all of your materials, so you should feel free to get right to the substance of your arguments. And I understand that we have a commuter issue on one of our cases, so the last case on the list is prepared to go after this case, is what my court officers have told me. So I appreciate your flexibility with the schedule. So our next case, and I apologize if I mispronounce this, NIAL LUU versus FALLON Service Inc. and another, 23P340. Mr. Liu.
Greetings, Your Honors. My name is NIAL LUU. I'll be representing myself. This is the first time I'm doing this as a pro se, so please bear with me. I have two appeals, one for the summary judgment, dismissal of my complaint, and then the denial of the 60B motion. I was informed that if my first appeal was successful, then there's no need to consider the second or something like that.
So your appeals have been consolidated, so we're hearing both of them today, so you should argue both of them today.
Yeah, that's my understanding. Thanks. So the defendants are requesting a de novo review hearing, which is, from the beginning, as if this is the first time being heard. There's no deference to the lower courts. So my first point would be to address the dismissal of the complaint. The lower court said that I needed to cite some legal theories that entitled me to remedy, but the Supreme Court stated that stating proper legal theories is not required and not enough to dismiss the complaint. And when it's in the interest of justice, the plaintiff should be allowed to amend the complaint. In that case, which I cited, is Johnson v. City of Shelby, and that case is pretty much identical to mine, and in which that both cases, both plaintiffs were wrongfully terminated for reporting illegal activity. Both plaintiffs had their complaints dismissed by the lower courts for not citing applicable statute, and the Supreme Court quoted directly said it is unnecessary to set out legal theory for the plaintiff's complaint for relief, and the court should freely give leave to amend a pleading when justice so requires, which we did ask to amend, but that was denied. And also it was denied because the judge said that we didn't cite the correct proper legal theory, but that's not enough to dismiss. The only thing that's required is to allege the facts that entitled me, the plaintiff, to remedy, which we did do. We alleged that I was wrongfully terminated and retaliated against for reporting an incident of patient abuse and neglect, and that the supervisor acted willfully, had conducted, or there was willful misconduct from the supervisor. So those are the facts that I alleged. So my complaint should not have been dismissed, but for argument's sake, I could go through the dismissals, the reasons for the dismissal of each count, because those are wrong too. Those are incorrect too. So the dismissal of the first count, the judge fails to acknowledge that Fallon did violate Massachusetts General Laws, Chapter 149, Section 187. Initially, the counsel that represented me, they improperly or incorrectly filed under Section 185, which is for public employees, and what they meant to file under is 187, which is for healthcare providers. We asked to amend, and the judge denied that. He said that 187 doesn't apply to EMTs, but it does. He incorrectly interpreted or did not comprehend that Section 187 does apply to EMTs. as stated in my brief, it clearly says healthcare providers, an individual who is licensed, who is a licensed healthcare provider under the provisions of Chapter 112, including but not limited to, lists different professions like registered nurse, physicians, chiropractors, psychologists, social workers, and then it says, or any other healthcare provider, or any other healthcare provider, including EMTs, who perform healthcare.
I don't see where it says
related
including EMTs.
Excuse me?
I don't see where it says including EMTs.
That's what I'm trying to say. The statute says, but not limited to. So it's not limited to those.
We're adding the including EMTs.
Yes.
Okay.
It does include, because it says not limited to, and it includes any other healthcare providers that perform healthcare-related services. So that includes EMTs. It's not limited to those titles, and it includes EMTs because any other healthcare provider that performs healthcare-related services. So I'm saying that the judge was wrong to conclude that Section 187 does not include EMTs. It absolutely does, because it doesn't list other professions like anesthesiologists, radiologists, but of course it includes those professions because it's not limited to those titles, and it includes any other healthcare providers that perform healthcare services. So that's my rebuttal to the count one. Also, if for some reason the judge thought it has to label like specifically EMTs, that statute violates equal protection, the equal protection clause. You can't offer whistleblower protections to doctors, nurses, and then not offer that to EMTs. That's a violation of our constitution. And also, another part of the Massachusetts Constitution, Article 11, it says that plaintiffs have there should be a method of remedy for all injuries. So for the judge to say like there's no remedy for EMTs for whistleblowers, there has to be. There just has to be under the Massachusetts Constitution, Article 11, there has to be, and there is, which is Section 187. It includes any healthcare providers, which includes EMTs. So the judge was wrong to dismiss count one, and now going to count two. The judge indicates or incorrectly claims the plaintiff did not indicate that Liu was terminated in violation of any recognized policy. We did cite that. We did tell the judge that I had to report it under 105 CMR 170, which is regulations for EMTs, and it clearly states that Fallon had to report the incident of patient abuse and neglect within 7 days. And I myself had to report it, or I would be at risk of losing my license. So the judge, in his dismissal, in his summary judgment, he said that 105 CMR 170 does not apply to Fallon or myself as the EMT, but it clearly does. So if he's incorrectly making that statement, then obviously he didn't understand the regulation. Therefore, he could not have made a sound judgment. So there should be a reversal on that count too. And then dismissal of count three, the judge erred by saying that there was no exceptions. He failed to acknowledge the exceptions to the exclusivity provisions of the Workers' Compensation Act. There is an exclusion. So the plaintiff can file like damages, like emotional distress, under MGL Chapter 152, Section 28, willful conduct by employer, and it states that with proof that the supervisor acted willfully or there was willful misconduct, then there is an exception for the plaintiff to seek those damages under.
Did your lawyer, though, raise that issue, the negligent infliction and the intentional interference with contractual relations
Yes.
in the 60B motion?
Yeah, he
Where?
also, I'm not sure. I think it should be, or in the reply of the, no, I think it was not in the 60B. It was in the reply for the summary judgment, I think.
So that
Or
might be a
6B.
technical problem for you, that it wasn't raised in the 60B.
It was
Not the
raised.
first two claims, but the second two claims. I have
Wait, what?
your lawyer's motion in front of me, and it says nothing about those two claims.
Wait, about what claim?
Negligent infliction of emotional distress and intentional interference with contractual relations. That's not raised in the 60B motion. We'll take another look at it, but I just want
Yeah.
to give you a heads up on that.
Because I got that statute from one of the replies. So it was either a
You
reply.
might have filed it before the judgment issued, but then in the 60B, challenging the judgment, he didn't really challenge those two claims. From what I look at it again, we all will, but I just wanted to put you on notice that that might be an issue, that
Okay.
those two claims might be problematic for that reason.
Okay, but I'm still asking for the de novo review from like the
Understood.
beginning.
I understand.
Yeah, so I would still challenge that now, even if my attorneys didn't challenge it then, I'm challenging it now. So I don't think that should be an issue. And then, so I've stated the rebuttal for count 3, and now I'm going to the dismissal of the 60B motion. Judge Reardon incorrectly claimed that the amended complaint alleging violation of Section 187 would be futile because he incorrectly interpreted 187 to wrongly exclude EMTs. The amended complaint would not be futile, and therefore he's just plain out incorrect. And then second point, he refers to the definitions of healthcare provider in another statute, MGL Chapter 231, Section 60B, to improperly apply to MGL Chapter 149, Section 187. In that statute the other secondary statute that's not really relevant, it clearly states that the definitions in that section is for that section. It does not refer to any other chapters or any sections like many other statutes do, which clearly say these definitions apply to, X, Y, Z. This one says for this section. It's only for that section only. Those arguments is just futile, technically. Like it just does not matter. But just and then my third point is Fallon raised or cited a case law, Perez versus Bay State Ambulance, and falsely claimed that the Massachusetts Supreme Judicial Court concluded that EMTs were not healthcare providers in Section 187. And Judge Reardon misunderstood that decision. I don't think he read the decision because in that case, they were only speaking on Chapter 231, Section 60B, not 187. They did not decide that EMTs were not included in 187. So that was just misquote. It's just not a proper argument. And just for argument's sake, if 60B did apply, then it still includes EMTs. Because if you read the language in 60B, it says, for the purposes of this section, a provider of health care shall mean a person, corporation, a person, which is EMTs, licensed by the Commonwealth to provide health care or professional services. And then it says, as, it labels a bunch of positions, and then it says, the key point is employees or agent thereof acting in the course and scope of their employment. So if I'm reading the key points for this purposes of this section, A healthcare provider shall mean a person licensed by the Commonwealth to provide healthcare or professional services as an employee or an agent thereof, acting in the course and scope of his employment. So a person, EMT, licensed by the Commonwealth to act in his scope, which includes me. So even if they wanted to say 60B should be applied to 187 for some reason, it's still futile. It still includes EMTs. Yeah, that's pretty much all my points. But mainly, we wouldn't have to go through all those points if we just upheld the Supreme Court's authority, which says that the plaintiff does not need to cite proper legal theory, only needs to cite the alleged facts that entitle them to remedy, which I did. That should be sufficient. And in certain cases where the plaintiff would like to amend, the court should freely give leave to amend a pleading when justice requires so. So
Thank you. We're going to have to leave it there. Yeah. Thank you so much. Please don't leave. Have a seat at the table.
All right, thanks.
And Mr. Egan?
Good morning. May it please the court. My name is Tim Egan, and I represent the appellees in this case. There's a few things I wanted to clear up right off the bat. This case is de novo review, which we've pointed out. As to the motion to dismiss, the 60B is an abuse of discretion. And so there's a difference there that I don't think the appellant appreciated. Additionally, and I think this is quite important, there was no motion to amend the complaint ever filed in this case, whether when there was counsel or thereafter. So I think I heard a couple of times that there had been a motion to amend that was filed. I think if you look at the docket, and I think at a couple of points in his brief, he also says, if I would have done it, I'm sure it would have been allowed. So I think that there's a major waiver problem here for both the Rule 60B and certainly the arguments 3 and 4 as to Mr. Mont being personally liable and also to the infliction of emotional distress. The additional argument that I heard here today, if I could just get it out of the way, is that that the exclusivity provisions of the workers' compensation statute are somehow not applicable because there is a Section 28 of that regulatory scheme. That has to do with when there's such egregious conduct, intentional, willful conduct on the part of the employer, that if it could be that there were railings that were intentionally not bolted down. It could be emotional distress. It could be any number of things. But all that's saying is, in those situations, not only do you get damages, you get double damages. And the section says it's only applied in rare circumstances, but it's commonly applied in the context of workers' compensation claims. So with that said, I'd like to go back to the start. De novo, and point out that the complaint that was filed very clearly indicated that it was seeking whistleblower protection under Section 185. It's plain from the text of that provision that only applies to the Commonwealth and its agencies, et cetera, et cetera. And so Judge Reardon properly dismissed it.
Well, so as far as I could tell, you didn't raise that.
Right.
The judge sua sponte raised the definition of employee. Am I wrong about that?
No, you're correct.
So when a judge raises an issue sua sponte, doesn't he need to give the parties a chance to respond to that? Presumably if he had said, well, hey, wait, what about this definition? The plaintiff would have said, I just want to change not even a word in my complaint, just a number in my complaint.
That is
why didn't he have the obligation when he's raising something sua sponte to at least give the parties a chance to say, hey, wait a second, there's a single digit in my complaint I want to change?
At that point, the parties could have, and it was represented by counsel at the time, could have moved to amend, or as they did, they could have filed a motion to vacate, which they did. And at that point, it becomes a matter of discretion, which we'll get, I can get to it right now if you like. But there was very tactical reasons why they chose to advance under 185 versus 187. 187, as we're going to discuss in a few minutes, doesn't include EMTs. So their professional judgment was, we're going to proceed under 185 and say that they're an agent of the Commonwealth because they're licensed with the Commonwealth. That's a loser argument, but it's an argument. And so they had the option of making it. Under the statute for vacating a judgment, the idea that, oops, that didn't work out, let us do it again a year later, the judge has complete discretion to accept that or not. And in this case, the judge did not accept that. And the judge also went further and said, even if I had accepted that, I don't believe 187 applies either. And so if I could, I want to get to that a little bit later because I want to talk about the, I talk about it right now.
Yeah, let's explore that. Fallon is licensed by the Department of Public Health, right?
Correct.
And it provides healthcare services, right?
Correct.
So it's a healthcare facility under 187A, right?
Yes.
Okay, and the plaintiff here performed healthcare services under your control, right?
I think they're different services. They're first responder services, but if I could, and I think this gets to
Well, let's break it down. He was under your control, right?
Yes.
And you're saying that EMTs don't do healthcare services, healthcare-related services?
I'm saying that they're among many professionals that perform healthcare services that aren't covered by the statute.
The statute includes any other healthcare provider who performs or has performed healthcare-related services for or under the control of a healthcare facility for care-related services.
Right.
How does he not fall within that?
Well, the SJC has already addressed the situation, and that's why I think that the court,
The SJC
in analogous,
interpreted a statute that doesn't have that language, right?
it has very similar language, and what the SJC said in that case, and that's the case that was referenced earlier, Perez versus Bay State Ambulance. They said, they listed off who it applied to, and they said, plaintiff correctly notes that EMTs are not included in the legislature's list of providers of health care. The judge found that EMTs were licensed by the Commonwealth and were within the spirit of the law, and that therefore a medical malpractice claim against an ambulance company and its EMT employees had been brought before the medical tribunal. So they were looking at the medical tribunal statute, but they also focused on that narrowly and noted that the legislature has consistently excluded EMT specifically from who is covered as a medical health care provider. So I think what the judge was doing is not misinterpreting the statute or thinking he was applying the wrong standard. He was saying that looking at the legislature and trying to interpret the statute, I'm going to say the legislature has been consistent here and has consistently found that EMTs and others that do provide medical services are not covered as a medical service provider.
So let's just pretend for a second that we think he is covered by 187.
Mm-hmm.
What's your best argument that where a judge sua sponte raises an issue like this, that it's not an abuse of discretion to let the parties make that small change?
Well, it is in the judge's discretion, and I believe it would still be futile because the reason that Mr. Liu was fired had nothing to do with his reporting an injury. It had to do with the fact that he videotaped it.
The complaint literally alleges that you fired him for reporting you to OEMS.
But it also says that he refused to delete the tape and acknowledged that the reason he was being terminated was because of the tape. We wouldn't be here today
Where does
if
the
it was
complaint
tape.
say he acknowledges he was being fired for having the tape?
I believe he was told to erase the tape immediately. I don't have that.
Right, but since his direct supervisor praised him for doing the recording, I don't know why this complaint doesn't state that he was fired for reporting you to OEMS, not for the recording that he did.
Well, it's a violation of state law, federal law, and the written policy that said it's absolutely essential that cameras never be turned on with an electronic device while treating a patient or with a coworker. So that's the problem.
But on a 12B6, why does the complaint establish that that's why he was fired and not for the reporting, which is what the complaint alleges.
Well, it's the four corners where it's clear from the four corners of the complaint. If he said nothing about the fact that this was videotaped, that just that he made a complaint, that might be something. But here we have, the actual policy reason, and I'm talking about both legal policy and the policy of Fallon Ambulance, as he admitted why the violation that he committed.
So according to this complaint, he shows his supervisor, Miss Braley, the video. She asks him to forward the images, which if it's actually a wiretap violation would also be a criminal violation on her part. And then they meet with him on January 2nd, and they just tell him to delete it, but they don't fire him. And then they fire him after he reports to OEMS. So why does that establish that he was fired? If he was really fired for the videotaping, wouldn't his supervisor have fired him right away instead of waiting until he reported it?
I believe it says in the complaint that he had told them at that meeting that he intended to report this. I'm going by memory, so I see you have it in front of you.
I don't see that, but how would it matter?
Well, I think the timeline's important because he was told to delete it, he wouldn't delete it, and then if he said at that point, I'm going to go and report this, then I think that's more important than saying once he reported it, then we fired him. I think that does make a difference.
Well, it says, in direct response for this report to OEMS, Mr. Liu was terminated by Fallon on January 17th, 2020. Which was 3 days after he reported to OEMS.
And I don't even know if the company would have had notice of that yet. But be that as it may,
Why do you think it's a wiretap violation? I didn't get that.
Because it's surreptitious taping of someone without their permission.
Where in the complaint does it say it was a secret taping?
He admitted in his papers that she was in an altered state and couldn't respond. Couldn't give consent. That was what she said. That's what he said, is that I couldn't obtain consent because she was in an altered state. I don't know if it says that in the complaint, but it says it in the record. Part of the record that he submitted.
Is it something you can consider in a 12b-6? Is it in something you can consider in a 12b-6 decision?
No, I don't think it is.
Okay.
Can we go back to the potential amendment?
Sure.
And the decision of the judge was February 23rd, 2023, I believe. Mm-hmm. And then the plaintiff files a motion for relief from order 1 month later. And in that, I won't count how many, but he repeatedly talks about how it could have been filed under Section 187.
Right.
Why isn't that basically proposing, I will amend it if you reconsider your decision?
He could have done that. He could have proposed to amend it, but he did not. And I think it would have been futile. And I don't think he wanted to address it at that point.
Why would it have been futile?
I believe, first of all, because EMTs are not covered under the statute, both expressly and impliedly, and there are good grounds why they wouldn't be covered. And secondly, the judge was of the mind that this, and I think correctly, that he was fired for a clear violation of state, federal, and company policy.
Isn't that a factual determination for the jury based on the complaint? I mean, the complaint, I won't go back to it, but it does allege that on February 17th, he's fired for saying he's going to report them. So that's a finding of fact that you think the judge can make on, I guess, a motion to amend?
Well, he's admitted to the facts of what he did that was a violation of policy. I mean, he admitted to what he did. He said the quiet part out loud.
The reason for the firing, that's the factual determination that the jury has to make, isn't it? In a whistleblower case?
I think it's been in the four corners of the complaint. I don't think it is. And I don't think the
Well, I don't
EMTs
think
are
any
covered anyway.
business usually admits that they fire somebody because the person's a whistleblower. I think they usually contest that. and that's usually what goes before the jury. So in this case, Fallon would argue in their answer, we didn't fire him because he was going to report it. We fired him because of the surreptitious taping. But that's a question of fact for the jury to decide.
Right.
So why is it appropriate for the judge to deny the motion for relief from order and judgment so the plaintiff can then amend his complaint? I mean, it's clear, I mean, at least it's clear for me in reading this motion, what the plaintiff is saying is, you should not allow the decision you did because I will amend my complaint for it to be 187.
But he didn't do that.
But that's because the judge said no to the motion for relief.
The judge had discretion to do that.
And why, tell me why, and this is where I'm losing you.
Okay.
Why isn't that an abuse of discretion?
Because in the statute, it says what is considered to be a healthcare provider. And then what Mr. Liu wants to do is create another whole class of individuals who are also healthcare providers. If the legislature wanted to do that, it's not like there was a mystery as to what an ambulance was and what services they provided.
Is there any part of, it's Judge Reardon, and Judge Reardon's decision on either the original motion or in his denial of this relief from joinder, where he says that this would not be an appropriate under 187?
He adopted our entire argument in opposition, and then also said, and I think that as well, it's a paragraph decision, but he adopted our entire opposition, so that would include the fact that it was also.
Is your opposition in the record?
I believe it is.
Maybe I missed it.
It's in our supplemental.
Supplemental?
Plan, yeah.
Okay.
If I could just get 3 words in on the policy, determination of policy. If that were allowed, if this were allowed to go forward, everybody that was terminated, an employee at will that was terminated, would claim to be a whistleblower. And then there'd have to be a fact-finding in every sense. It would completely obliterate the at-will function of at-will employment. Because
And we're going to have to leave it there.
Yeah, that's fine.
Thank
you very much.
Thank you both. The matter is under advisement. Do we have an update? Thank you, AJ. All right, well, let's do case 6. Can you let Mr. Shania know that? So we're going to go to the 6th case right now, which is KAYCEE Weeks and another versus ALANE STALCUP and another. I'm sorry if I've mispronounced those. This is docket 23P997. And it looks like we're going to hear from Mr. Aaron first.
Still good morning.
Just close to a good morning.
I know. My name is Alan Aaron. I represent the appellants Stacy and Shane Weeks. A stipulation of dismissal is not a release. The underlying case in this matter was a summary process for non-payment of rent. The waiver and dismissal contained in this stipulation related only to Weeks's claims for non-payment of rent and the STALCUP's counterclaims based on the conditions of the premises.
All right, so let me ask you a question. I'm looking right at paragraph 6 of the stip. And it says, except as to enforce the terms of the stipulation, all parties waive, my emphasis, any claims and counterclaims.
That's
not limited to the
But that only relates to those issues raised in the complaint.
It doesn't say that. Right? They could have said, all parties waive any and all claims and counterclaims as to the summary process action and cite the docket number, but they say all claims. Any means any.
But the claim didn't exist at that time.
All right, so I want to ask you then, I thought you might say that. The SJC decided a case in 2023. Neither one of you cited it. So
Which
it's
case is that?
Dacey versus Burgess. And I want to read you a quote. It's a little bit long, but I want to ask you to respond to it because I think this covers your argument. They say, as a jurisdictional matter, the Housing Court has broad authority to resolve civil claims and counterclaims that relate directly or indirectly to the health, safety, or welfare of any occupant of any place used as a place of human habitation, as well as the authority to resolve all housing problems, including all contract and tort actions which affect the health, safety, and welfare of the occupants or owners of such housing. There were no contract or tort actions pending in the Dacey case, but they resolved all claims. I see that as similar to this case.
Yeah, but there was cases decided after that, which I think are contrary to that.
After 2023?
Oh, 23, okay. No,
I mean, if they are, please tell me, because I want to look at them.
No, I'm sorry. But still, we still have an issue that there is the claims raised in the second action were not known at the time and could not have been raised in the summary process action.
Can I ask you about not known? Couldn't it have been known? Because that might...
No, because my clients didn't have possession.
But they are landlords, correct?
The fact that they are landlords is irrelevant. The fact is that they could not get into the premises.
Don't landlords always have a right with proper notice to a tenant to go and look into the apartment to see its condition?
That shouldn't be held against the landlords in this case.
Why not?
I mean, the tenants essentially knew that they had caused some damages.
But didn't your client know that? Isn't that why this stipulation says the plaintiff may keep the security deposit?
I'm sorry?
This stipulation says the plaintiff may keep the security deposit.
Right.
Doesn't that mean both parties understood that there was some damage to the premises?
No, not necessarily. That was just part of the negotiations.
Why would you keep the security deposit if there weren't damages to property?
Because there was unpaid rent. And the security deposit was going to be applied towards the unpaid rent. So therefore, both parties, the tenants waived their right to make a security deposit claim, but they received a waiver of several months' rent. So that's why that provision is there.
So I guess this is a follow-up to Justice Blake regarding the contract. How do we know that this was, you say, because the claim hadn't existed yet?
Right.
How do we know that?
Why?
Maybe your client didn't know about the damages, but the claim may have still
any
existed.
claim for damages could not have been raised as part of the summary process action, because that's Ginwala Bizarro. And Ginwala versus Bizarro stands for the theory that in a summary process action, a landlord is only allowed to claim rent and possession, not allowed to claim damages. So therefore, if a landlord is seeking damages, it has to be part of a separate civil action.
Can a settlement?
I'm sorry?
Settlement in a summary process action? Can a settlement in a summary process action include other things?
It could, but...
So in this situation, if they had said in the contract, any and all claims, including any damages to the property, that would have been okay?
That would have been, and actually, Your Honor, when this stipulation was first, I prepared the original stipulation, okay? It had 7 paragraphs. I sent it to defendant's counsel. Defendant's counsel sent me back, in their own writing, a paragraph 8, which reads in part, plaintiff waives any claims against defendant for monies owed on the premises. That was deleted and not part of the summary, it's not part of the settlement agreement or the stipulation that was
That's
filed.
not part of the record. We can't consider that, can we?
Well, I mean, the panel raised that issue. So I think I have a right to argue
Did you tell Judge Mitchell-Munovar that?
I'm sorry?
Did you tell the housing court judge that? What you just told us?
No, I did not, because it wasn't part of the housing court judge. There was no colloquy. All right, it was a stipulation that was.
No, I mean when you filed this motion and the judge dismissed it, the new case. Did you tell the judge about this? How there had been a eighth provision that had been deleted?
I don't believe I did.
So when you say that it's limited to the claim and the counterclaim, how does paragraph 2 impact your argument? Because you dealt with personal property.
Right, but that has nothing, I mean, that is a provision that I put in all of my agreements. In other words, if the tenants left personal property, that could be disposed of by my client without liability. I think that's in every agreement for judgment.
To me, that's the same thing as damages. It's
I'm sorry?
in the
That's
same nature as damages.
Yeah, but personal property left is not damage to the premises.
No, but it would cost your clients at least energy and time, if not money, if they left a ton of stuff. Maybe they'd have to hire, I don't know, 1-800-JUNK or something to clean it out. I don't know why that paragraph is any different than a claim for damages.
It's absolutely different. Forgive me. It is absolutely different.
Right, I'm trying to understand how.
The damages, that's not physical damage to the premises. All right? That may be damages in terms of my client having to spend money, but it's not physical damage to the premise like walls, damage to the walls, damage to the floors.
So it's okay to have removal of personal property as part of the stipulation, even though that's not technically under summary process?
I'm sorry.
It's okay to have removal of personal property as part of the stipulation, even though that claim could not have been brought under summary process.
That is a provision that is in, as a matter of fact, with Tier 1 mediation.
Please answer my question first, right? Which is, personal property is not something you're entitled to relief for under the summary process statute, right? That would have had to been brought in a separate action.
That's correct. That's not possession and it's not rent.
Okay. But yet you disposed of it in this stipulation.
It was mentioned in the stipulation as it is mentioned in...
Well, it's not mentioned. It's a provision.
No, I understand that. But that's in every agreement. In other words, that if for every mediation, every Tier 1 event where the parties come to an agreement, that provision, any remaining property can be disposed of, and that's to protect the landlord in case the tenant leaves some property there.
Right.
But this is a much different situation because this is physical damage to the rented premises.
And didn't the tenants leave 2 days before the stip was signed? So there was time, granted, it was only 2 days, but the landlord could have gone in, no?
No, that time period, I think, should be irrelevant because, fine, with my computer, it states, yeah, November 15th, but after it comes off my computer, it gets sent to opposing counsel, all right? It took a day or two to finalize this, and then it wasn't docketed. It was docketed on this November 17th, 2021, 2 days later. So that 2 days, my client didn't have possession until the 17th when this was officially docketed.
What does the stipulation, paragraph 6, when it says all parties waive any claims and counterclaims?
Right.
What are any claims and counterclaims?
Any claims relate to strictly the rent that was owed and the defendant's counterclaims for conditions of the premises.
So how is that different from 7 then?
I'm sorry?
How is that different from 7 then? What does that do that 7 doesn't do then?
That's right, that this case should be dismissed with prejudice, and that's the issue of my client claiming unpaid rent and the defendants claiming damages. But
what does 6 do that 7 doesn't?
If you took 6 out...
I'm not sure that there's a big difference between the two, but the fact of the matter is that there was no, and this is an issue raised by the trial judge and counsel. They do not talk about, I think this is possibly a case of first impression. They talk about a release, but there was no release in this case. This does not act as a release, okay? I think the closest that comes to this case are cases regarding issue preclusion and res judicata, and I've cited 3 cases in my brief, which state, if you bear with me for just a second, I cited 3 cases which stand for the proposition that where information on which a second action is based was not discoverable in a first action, those claims are not waived. And these damages could not have been waived in the first action because my client did not have possession and couldn't have possession. They were not legally allowed to go into the premises until after the stipulation was filed.
Why is that?
I'm sorry?
Why weren't they legally allowed to go into the premises until the stipulation was filed?
Because they didn't have a right to.
Doesn't a landlord have a right to inspect the premises they own?
They had a possible ability, but that wasn't allowed.
Wasn't allowed by who?
I'm sorry?
Wasn't allowed by who?
The parties did not agree that my client could go in and have possession, so they could not have known.
Appendix page 16, I'm reading from the lease. Inspection of premises. Landlord and landlord's agents shall have the right at all reasonable times during the term of this agreement and any renewal to enter the premises for the purpose of inspecting the premises and all buildings and improvements thereon.
Right, but number one, they need permission from the tenants.
No, it doesn't say that. It says at reasonable times to enter the premises. That suggests to me you don't show up at 3 in the morning.
But the fact that they didn't exercise that should not be held against them.
Why not? You have a right to inspect the premises. You decide not to. Why wouldn't that be held against you in a question, if the question really is whether you could determine the condition of the premises?
This is a very difficult landlord-tenant matter. The landlords and the tenants did not get along at all here. Okay, so I think my client would reasonably expect under the circumstances that even if they had asked for permission, that would not have been granted.
Is there
anything and there's nothing I could have done in the meantime to force the matter.
Is there anything in the record as to when the tenants actually left the premises?
I don't know. But I know that my client, even if they left a month early, that doesn't mean my client had a right to possession because the stipulation was not filed.
Well, again, if they left a month ago, the landlord, pursuant to the tenancy agreement, could go in at any time to check for damages.
But he still needs permission from the tenants to do it. He
That's
just
not
can't.
what we don't have to go back, but that's not what the tenancy says.
It's a practical matter. A landlord just can't go knock on the door and say, I'm coming in to inspect. All right, the courts require at least, except in the event of an emergency, at least a 24-hour notice. Okay?
Did you say any of that to the lower court? Did you tell the lower court how you couldn't get in even though the lease requires it?
No, I did not. So, but we're
going to have to leave it there. Your time is up.
Okay.
Counsel for the tenant.
Good afternoon. I'm Tom McMerovitz. I represent Elaine and George Stalcup, the former tenants in this matter. May it please the court. Your Honors, I'm somewhat in the same position as you since I was not part of the lower court proceedings. And much like you, I am viewing the record as to whether or not the motion for summary judgment was properly allowed. And in this case, there's nothing in the record about this supposed paragraph 8. Significantly, there's nothing in the record opposing the motion for summary judgment in the form of an affidavit from counsel about this delay between negotiations and the filing of the stipulation, or from the landlords themselves about the fact that they couldn't get access, which is what you need to oppose summary judgment to create a genuine issue of material fact.
So let's assume that's true. Let's assume this is a normal summary process action and there's an eviction and the parties go in and reach this stipulation. But the tenants still live there. They're ready to go. They go back after the stipulation is signed. They get their belongings, and on the way out the door, they smash the place up to bits. Is the landlord have no recourse in that situation based on what this stipulation says?
But that's different than what this stipulation says, because the stipulation says, the first paragraph, that the tenants have vacated and ceded possession of the apartment. So even dated on the 15th, notwithstanding any delays associated with negotiations and filing, the landlords admit themselves that the tenants had vacated. And so there's no misunderstanding, that there's no issue with whether or not the landlords either had access or could have had access. And as Your Honors pointed out in paragraph 13 of the lease, it doesn't say that the tenants have to agree to anything. The landlord simply has to provide notice and could have done so. So the response to the first argument is, it's significant that it's mentioned in the stipulation that the tenants have already vacated. It's then filed, and notwithstanding that, the landlords also had a right under the lease to conduct inspection on proper notice. As the motion judge pointed out, had there been such reservation, the landlord simply could have inserted a reservation in the stipulation, reserving or carving out landlord's right to pursue property damages upon having an opportunity to reasonably inspect the unit, which, as Attorney Aaron, I practice in housing court, and that's typically done as well. But in this case, that wasn't included. And I forget which one of you asked the question, but regarding the stipulation to dismiss without prejudice, I believe it was Justice Ditkoff looking at paragraph 7 versus paragraph 6. Had there been no paragraph waiving any and all counterclaims, then I think the argument that the landlord is prevented from pursuing property damage under a summary process case, that argument would have been more persuasive. But they went ahead and included this provision where both parties waive any and all claims and counterclaims, which is not necessary in a stipulation with prejudice. But by doing that, it's clear that the parties intended to just go their separate ways and turn the page and close this chapter in their lives. So the case of Ginwala versus Bizarro, I don't believe that involved a case where there was a stipulation like this between the parties. I read the case. There was a summary process action, and then the landlord brought a separate action afterwards. But that did not include a stipulation like this. And Justice Blake, the Dacey case, I think, highlights what you had pointed out. In that case, I'm familiar with the case, although it wasn't cited. It was landlord had sought access to the unit to conduct repairs. As typical, both parties were then led into mediation. They entered into an agreement under which the tenant agreed to vacate the premises by a certain date. Once that date came and went, the landlord then sought to enforce that agreement, and the issue there was the tenant was demanding that the landlord nevertheless still had to file a summary process action, and the court held otherwise. The court held that no, under 186, I forget the section number, but that allows for the parties to agree to something beyond what is traditionally put into place, which is a summary process action. So without these affidavits or without anything in the record supporting this question of fact, there just simply isn't any facts or law supporting the plaintiff's position, which was what was represented to the motion judge. And motion judge disagreed with that, allowed summary judgment. And I would ask you all to disagree with it and affirm the lower court ruling. And I have nothing further unless
I don't see any other questions. Thank you very much. The case is under advisement.
Thank you very much.
Ms. Montgomery, how are we doing locating?
All right. No such luck.
I'm worried that he said his train is being pushed. That makes me nervous. Mr. Shania, have you heard from him in the last 20 minutes or so?
I haven't heard at all from him at all. He hasn't called me, and I don't have his cell number.
So the last update we had was at 11:34, to be precise, and it said Attorney Gauthier's train is being pushed towards North Station. He said he'll be here in 30 to 40 minutes, which is definitely now. Oh, hold on, we may have breaking news.
Or not.
Or not. AJ. All right, so here's what we're going to do. I'm going to take a brief recess. We're going to go out back, talk about this morning, and then let's give it maybe another 15 minutes and then see if we can locate him. In the meantime, can we still try to reach him on his cell from the clerk's office? That would be awesome. All right, so I guess stand by. I know you drove out from Western Mass, but hang on for a little bit and see if we can get this done.
I'm staying overnight because I have a case tomorrow here, so.
Oh, easy then. We're not letting you go. No.
Okay. You know everything.
Mr. Gauthier, we've been worried about you.
I have been worried about me too, Your Honor.
You didn't cause the train to go out of power, I hope.
I don't believe I did.
Because you never know these days. Everybody's safe, though. There was no accident.
So before the Brandeis stop, the power on the train went out, the lights and the brakes, so it coasted, I guess, to a stop at the Brandeis intersection at the university, which blocked the road north and south. So even cabs and Ubers couldn't come in.
Oh, dear God. You were in the crossing?
We were in the crossing at Brandeis. So we had to wait for the next train from Wachusett to come and push us into Porter. And that took about however long the next train was, about 2 hours. It was hair-raising.
Hope you have a different way home.
I don't. I have a return ticket on the train. It's okay. I think I spoke with my brother, and I think I'm going to join him in spending the nights in the city before oral arguments. I think it'll reduce the stress from, because we travel from Western Mass. So
I know.
It's a journey for both of us, more so for him.
Well, I'm glad you're okay. So are you ready to go? All right, let me call the case then officially. So this is John Doe 3271 versus the Sex Offender Registry Board, docket 23P937. Mr. Gauthier, when you're ready.
Yes, Your Honor. Thank you. Good morning, Your Honors. May it please the Court. Edward Gauthier, representing the plaintiff appellant John Doe. As this Court can see, this case has been pending since the 2013 motion by the Board to increase my client's classification from level 2 to level 3. It went to the Superior Court twice, remanded. The operative decision is from 2020, so essentially everything before that is water under the bridge. I'll get to issue number 1. And in this case, we have a man who committed a contact sex offense against children in 1985 and was finally classified level 2. Then committed a non-contact continuing sex offense. Possession is a continuing sex offense. It's not something you do on one day. It's just something he broadly did over a period from 2012 to 2013. And as a result of that, the Board increased his level to level 3. Our first issue is that the hearing examiner didn't make a distinction between the likelihood of Doe committing a contact versus a non-contact sex offense. And in Doe 7083, the Supreme Judicial Court says when you have a case like this, where you have a sex offense from the past and one from the more present, the primary focus would likely be on the recently committed crime. And in 496501, the SJC said, in assessing risk of danger, you need to focus on the severity and extent of harm that would result in the result of sexual reoffense. So the question is, how dangerous is Doe? If he is a high risk of committing a contact sex offense, then perhaps he is a level 3. If he's a high risk of only committing in the privacy of his home possession of child pornography, arguably he should not be a level 3. So the crux of our
Can I ask you about that alone?
Yes, sir.
Is it true that you cannot be a level sex 3 offender if you only, and only is in quotation fingers, possess child pornography?
There is no decision that puts a bright line rule that says only a non-contact sex offense means you cannot be a level 3 sex offender. However, language from the SJC focusing on the severity and extent of harm and the rationale for a level 3. The idea of a level 3 is people in your community should be able to protect themselves from potentially being a victim of your sexual offending. So if the only thing that you can be said to be predicted to do is sit in the privacy of your living room and download child pornography, it doesn't make sense that anybody would be able to protect themselves from you by having your name and your picture on the internet. So our position is, and it's a industry-wide position, is that if you are not a risk of committing a contact sex offense, then perhaps a level 1 is appropriate, because there really is no benefit from your neighbors knowing of your situation. However, I would agree that Doe in this case did commit a contact sex offense in 1985, so he is not a purely non-contact sex offender. The issue is the hearing examiner did not explicate in her decision, is Doe a high risk of committing a contact sex offense? Is Doe at risk of committing a non-contact sex offense? The hearing examiner determined that he's at an increased risk of committing a new child pornography offense. If that's true, that can't, in our position, justify a level 3. And she did not explicitly find that he's a high risk of committing a contact sex offense.
And how do we fit into the equation the not an offense per se, a criminal offense, the 14-year-old on the couch?
The Judge Squires-Lee in 2020 in the Superior Court did hold that the hearing examiner's focus on that was arbitrary and capricious. This court, of course, is not bound by a finding of a lower court. However, I don't know if the board is going to contest that the focus on a 2013 relationship where the boy was questioned and specifically said that Doe had no funny business. The boy never alleged that my client did anything untoward towards him. I agree with Judge Squires-Lee that a focus on that alone to elevate a risk of reoffense and degree of danger. We're focusing really today on degree of danger. The risk of reoffense, and of course under 496501, the board has to prove all 3 elements by clear and convincing evidence. We're really focusing on the board's failure to produce clear and convincing evidence that Doe presently, at his age, given his 24 years of offense-free time, his then commission of a non-contact sex offense, then his sex offender treatment programming, his counseling. We are of the position that the board did not prove by clear and convincing evidence that Doe, given all of those circumstances, currently poses a high degree of danger to members of the community such that active dissemination, both by the internet and police, is required to keep the community safe.
Since you acknowledge that we're not bound by the judge, let me go back to the 14-year-old on the couch. That was a violation of his, I believe, his probationary terms, correct?
Yes. He had 2 offenses of possession, 2012, 2013. The boy was, after he was placed on probation for the first, then he had the issue with the boy, then he was found in possession of more child pornography. His probation was revoked and he was given a prison sentence as a result. So yes, he did violate probation. He had an order of no contact with anybody under 16.
So a violation of probation where he has contact with a minor, why is that? Why, I guess I'm flipping it on the judge for our purposes, why would it be arbitrary and capricious for the board to consider that as to whether he's a heightened risk?
Well, I can tell you the judge found that it was arbitrary and capricious because the hearing examiner found that although Doe violated the conditions of his probation, it was not a sexual misconduct of any kind. I believe the judge's position was, without evidence that Doe was grooming the boy or sexually assaulted the boy, merely being in violation of probation for having contact with a person under 14 was not sufficient to establish the element of the need for an upward reclassification from 2 to 3. I do understand under the catch-all provision, Factor 37, the board can consider anything and everything, which I think will segue into the next argument, that the board always considers bad stuff under 37 and never considers good stuff. In particular, the board, when applying mitigating factors on behalf of a sex offender, will adhere very closely to the language in the regulation. For instance, we take issue, I believe, with 4 different regulatory factors. One is age. The board doesn't consider age a factor in this case because although my client was 60, or gave it moderate weight, because although my client was 60, entitling him to maximum weight, he had, at least at the age of 59, an active sex drive. But the consideration of age as a mitigating factor does not apply only to an inactive sex drive. There are many different things that are part of why age is a risk mitigating factor. And Dr. Plow testified to some of the things that make an offender less likely to offend at the age of 60. One of them could be a lesser active sex drive, but other things in particular in my client's case, are the fact that he suffers from serious medical ailments. Those are part and parcel of why age. So that the hearing examiners is basically a black and white application. Yes, he's 60, but he still has a sex drive, so I can't give him full weight. It doesn't really take into consideration why age is a risk mitigating factor. And it's a risk mitigating factor for many reasons. Generally, as people age, they commit less offenses of all kinds. They're less physically active. They're less impulsive. There's just a myriad reasons why an older person won't reoffend, unrelated to their sexual drive.
But we don't have those here where the guy's actively violating his probation conditions, right? I mean, his antisocialness doesn't seem to have decreased as age, does it?
Well,
Or do you mean?
So he was questioned. After he was found in possession of child pornography, he was questioned. And I believe Dr. Cloud really honed in on this, that he possesses child pornography as an alternate to contact sexual offending. So the evidence, I think, suggested that the Doe still has, I think the board said, an interest in prepubescent children. But he uses the non-contact sexual offending of possessing child pornography as essentially his outlet to not engage in contact sex offending. But in terms of age, in terms of that factor alone, our position is age gets full weight because it meets the definition of the statute and or definition of the regulation. And above and beyond that, the cited two studies and the testimony indicate that he should get full weight for that factor. Another factor that we believe should have been considered was offense-free time in the community. Very briefly, Mr. Doe was in the community for 27 years without committing a new offense. He then did 2 years, then was in the community 4 years without committing a new offense. And again, the board rigidly applied factor 29 that says no 5 years in the community offense-free, you don't get any consideration for this.
But the examiner said, I give some credit for this, but not the most weight under this factor.
Well, the hearing examiner actually mentions this 3 different times. She says that I defer to the board's factor 29 on this issue and thus do not consider Doe's offense-free time in my analysis of his current risk to reoffense. She says I part ways with the doctor on this application, that 3 to 4 years of offense-free time matters, and then she circles back and references Dr. Plout's testimony regarding offense-free time and says, well, I give some weight credit for this, but not a lot of credit. So it's kind of difficult to tell exactly how the analysis of the hearing examiner squares with Dr. Plout's testimony versus the regulatory factor. But she didn't mention at all the fact that my client was offense-free for 27 years. And as Dr. Plout testified, the fact that he was able to remain offense-free with no contact sex offense for 27 years is very significant. And it should have been considered in terms of his ability to suppress his urges to engage in contact sexual offending. And the board not only didn't give real credit for that, but really didn't weigh or consider the fact that he was able, from his 30s into his 60s, to never engage in a contact sex offense.
If we agreed with you as to that factor, does that automatically reduce him from a level 3 to a level 2?
Nothing in this field is automatic, Your Honor.
So it would go back, and the hearing examiner could do exactly what the hearing examiner did, and this time say, give him full weight for the offense-free time in the community and still come out with a level 3?
Always. The hearing examiner can always give less weight, more weight to any particular mitigating, elevating, or high-risk factor and always churn out the same final result. However, I think if you consider all 4 of the issues we raised, which is with the treatment programming, his age, his offense-free time in the community, and the fact that the hearing examiner really didn't discuss in detail the 4 years of mental health treatment and how Doe, at the time of the hearing, was proactively engaged in services, taking his medication, how his life was very much different than it was when he offended. I think if I don't know exactly, because I don't think there's enough cases on this, that in the trial court in criminal cases, when you have a case on appeal, you address the substantial risk or harmless error for one issue. And you say, okay, this was preserved. Does this warrant a new trial? But let's say there's a second error. Does this warrant a new trial? I notice courts don't often just add them up in the defendant's favor. It's usually one issue has to be enough.
Oh, I don't know. We get lots of cumulative errors arguments.
Sometimes
That's what you're making here.
we always make the cumulative error argument, because if the board misapplied one factor, we can say, well, maybe it wouldn't have made a difference. But if they misapplied 4,
But 4 makes a difference.
if they didn't consider studies, if they didn't consider expert testimony, if they didn't make clear Doe's risk is of a contact versus non-contact sex offense. The question is in the aggregate. And of course, the court's not necessarily going to find that everything we raised is an error, but we do urge the court to look at any errors in the cumulative.
Can I just ask?
Yes, sure.
So as far as the age one, the examiner should be rigid on that, and once the age of 60, you get credit for it. But on the one about 5 years in the community, that's not to be rigidly applied.
No. What I'm saying is neither should be rigidly applied. He should get credit for age because he's 60 and because having an active sex drive is not necessarily equivalent. It doesn't necessarily knock down the consideration. We're not talking about the factors per se. We're talking about the science and the research. My time is up. I just want to say one final thing, that it has been 3 years since my client's final hearing, and as this court knows, he's entitled to reclassification. Yes. However, he has asked that this go forward regardless. Thank you.
I appreciate that. Mr. Shanai.
Thank you. If it pleases the court, David Shanai for the board. I was just reminded years ago I used to represent CPCS in criminal cases, and I brought cumulative errors all the time. Wasn't very successful with it, but brought them. And I think that this is a similar case. I don't think there were cumulative errors in this hearing's examiner's decision. I reread it again today. I think that this hearing examiner did a really good job of going through all the evidence in this case and laying out her reasonings for the level 3, and I think they were valid. I think the real issue in this case was that in May of 2013, he's put on probation because of possession of child pornography. In September of that year, he meets this boy, a 14-year-old boy. We don't know how. The boy says that he numerous times met with this plaintiff, and that even in the week that the police talked to him, he had met with him 3 times. And what's interesting about it, if it was a harmless situation, then why was it the plaintiff set it up so that they were designated spots where they would meet so the boy's parents wouldn't know that they were meeting? And it was inappropriate for him to be bringing this boy to his house. Now, whether anything happened at that point is immaterial. It's a red flag, considering the fact that at the same time, while he's on probation and having this relationship with the boy, he's amassed 10,000 images of child pornography, most of which are prepubescent boys, in sex acts and in provocative poses. So obviously, at the age of 59, he is still exhibiting some serious deviancy and deviant behaviors. And I think the hearing examiner really outlines that evidence as proof that this individual does pose a new risk to reoffend, and she does separate non-contact with contact and makes it clear this man definitely shows that he is a risk to commit a contact sex offense. And that's important to note because even Factor 36 says, yes, if you only possess child pornography, you are most likely a low risk to, or a low danger to the public unless there are other factors. And in this case, the factors are all there. And the hearing examiner also took into account that he has been stable in the community, that he is on his medications, that he does have a support network. But again, it was only 7 years earlier that he committed these acts while he was on probation, and the hearing examiner pointed out, obviously, committing crimes, being held criminally liable, being put on probation, having done sex offender treatment in the program, hasn't prevented him from committing sex offenses in the past. And that because he's only been in the community for 3 years, it's still, we have to see if the new sex offender treatment and his new situation is stable enough that he won't do it again. And I think the hearing examiner...
I'll ask you an impossible question.
Sure.
Are you aware of any situation where a hearing examiner has agreed in totality with Dr. Plowd's opinions?
Yes, I have. In general, I've had cases reduced because of Dr. Plowd. Other doctors too, but Dr. Plowd has had some of his testimony and evidence basis for a reduction in the classification decision. Because, you know, he's well respected, but in this case, he was overlooking evidence, and the hearing examiner really pointed out all the evidence he overlooked. In fact, the relationship with that boy, he discounted it completely. He says that the static 99 is for contact sex offenses. The person, this individual, comes out at a 4, which is a high, and then he discounts that. It was things like that. The hearing examiner laid out all of the reasons why she diverged from Dr. Plowd's belief that this individual posed a low risk for a contact sex offense, and I think she did a great job of doing that. So I think based on the record, I think the board's position is that as of 2020, the hearing examiner's decision that this individual now poses a high risk to reoffend with possibly a prepubescent or teenage boy was warranted.
Is contact offense defined anywhere?
Other than, I don't think, I'm trying to think if it's in the regulations or statute. It might be in the regulation, but I do know they base it mostly on the acts that are done. I mean,
the reason why I ask is because it was a term of his probation and he violates that probation and he is in physical proximity to a minor, could that be considered a contact offense in that situation?
no, and I don't think the hearing examiner ever considered this to be a contact offense. What the hearing examiner found is because he had contact offenses with like-age boys, and now he's having this inappropriate relationship with this boy and amassing 10,000 images of child pornography at the same time, and the inappropriate behavior of actually being on a couch with the boy watching a movie, I think the hearing examiner, that's a little different than someone just standing near a child and then having that be a contact, because that wouldn't be a contact sex offense. And again, I don't think the hearing examiner considered this actually a contact sex offense, more as a red flag.
I don't see any other questions. We're happy to take the rest of your argument on your brief.
Thank you.
Thank you both. The case is under advisement. Whether it's today or tomorrow, safe travels back. We are in recess. Thank you to the court officers, the court staff, our wonderful timekeeper, and we are adjourned.
This one back and